One. The instance of respondent will not circulate.
Will not.
Your appeal is that.
They're not doing from
Last 1 year. It is filed. Get it. 26.
After the NMC approval may not, all the students were other colleges. And for a student who are managing
Next week.
because next first week onwards the examination that they have to pay the fee to the examiner.
It is writ appeal.
No, my lords, writ petition, medical matter.
27. 26.
My lord, one matter, I'm having an order of eviction against me. What has happened is we filed I'm not the borrower in the matter. It's a loan matter. Loan has been taken by the husband. There is the difficulty between the husband and the wife. Divorce proceedings are going on. Now, by virtue of the order, they have taken on order to take possession of the property. Now, what has happened is I filed a memo saying that we will file an affidavit saying that we will repay the loan. Only thing is we wanted a documents to be given to us, which the bank has now interpreted because that order is missing in that matter. So now that there is a threat of eviction, they have said that they will come and evict me from the petition scheduled property, where I am presently residing with my 2 minor daughters. Therefore, I am making a request that the matter may be taken up expeditiously, because otherwise I will be evicted from the property, though I am willing to repay the loan.
Approach the bank and request the bank after 2 weeks. Yes.
With your lordship can permission. This is a matter regarding the allotment of site by the KHB, Karnataka Housing Board. It has been, first allotment has been made in the year 2013. Thereafter, he has filed 3 writ petitions, and all the writ petitions, it has been ordered to be considered. And the third writ petition, we have allotted the site. Now he is asking for the site to be the different site to be registered for the same amount he has paid for a smaller site. That has been ordered by the single judge. I have filed writ appeal against this order, and I have moved this court also for posting. And three times the matter has been posted, but it did not reach. Now the contempt proceedings are posted on 26/6/2026. Now, my matter has been posted on 1/7, writ appeal. In this circumstances, I request your lordship to post it either onto my writ appeal.
We'll post contempt on 1/7, yes. Contempt will be posted on 1/7. Just remind me. We appear in when the contempt is posted. No preponement of any matter. Yes.
Contempt.
These are connected matters. Challenging the action of the respondent authorities conducting drone survey and DGPS in respect of my quarrying license area, entire quarrying license area, which we have obtained the license in the year 2018-17 itself. From then, we have been paying royalty, etc. by MDP, and for that they are conducting audit reports and all that. All the reports are clear till the year 2022-23. Now, by virtue of this notice, they are planning to conduct a drone and DGPS survey day after tomorrow, 26, in respect of the entire quarry area for assessing the quantity which we have extracted from the quarry area. And the fact that all the reports are there from the year 2017-18 till 2022-23. But the rule now recently, in 2023, they inserted a new rule under which the drone survey shall be conducted prospectively. Now they want to conduct a drone survey in respect of the entire quarry area. Therefore, my submission day after tomorrow is the date.
Refused. Yes.
My lord, I'm mentioning a matter, my lord. Serial number 64. It's a fresh contempt matter. My lords had already overruled the office objection on the last date of hearing. By mistake, it has again come for office objection along with council submission. May it be taken up along with other contempt matters?
There is no office objection.
There is no, my lords have overruled the office objection.
Take up one when along with.
My lord, serial number 16.
Whenever it is reached, we'll take up.
Where?
Lie, give it. It is a contempt petition.
Contempt.
If it is possible. Learned advocate Miss
Preeti Karadini.
stated that there are no office objections and that all the objections are removed. Full stop. Heard learned advocate for the petitioner. Notice written.
Serial number 17.
9th of July. 9th July.
Obliged.
Lord, serial number 70, my lord. I appear for the complaint in this case. I pay for weeks accommodation to file my counter.
Pardon?
Matter is listed for framing of charges, my lord. Pays for last occasion, my lord, they have filed a complaints of that in terms of
File compliance.
Last occasion we
pays for weeks accommodation. I file my counter.
2 weeks.
Lord, serial number 16, my lord. I'm for the appellant in this case. Lord, in the
Serial number 16.
16, my lord. We are going to engage senior counsel. Any 15 days time may be granted.
On July 23rd.
Serial number 16.
Serial number 17, my lord.
My lord, serial number 37, my lord. Appear for the appellant. Raise for short accommodation. Serial number.
5th August.
Serial number 29, my lord.
Yes,
I have to-
Serial number 27, my lord.
yes, Mr.
I am for the contesting
Yes,
respondent.
you want to mention? No.
Yes,
Yes.
serial number 42, my lord, for the appellants in this case. Kindly pray for a week's time, my lord.
Which one?
42, my lord, serial number
42.
for the
24
appellant in this case.
24th July.
Right, interim order to be extended. Interim order to be
Will
extended.
be extended.
Serial number 17, my lord. Request for short accommodation.
Yes.
Serial 27, my lord. I am contesting for contesting respondent. Other
Serial
side is
number?
also here. 2 weeks time, my lord.
Serial number?
27, my lord. 2 weeks, I pray for 2 weeks time, my lord.
Okay.
It was converted from GM to PIM.
2 weeks. 25th of July.
My lord, serial number 15, my lords, 2 weeks, my lords,
Serial number
15.
15.
It also needs to be connected with the, there's a connected appeal, my lord, needs to be connected.
3 weeks.
Please, I'm afraid.
My lord, serial number 66, my lord, and connected matters, my lord. 3 weeks accommodation, maybe.
Which one?
66.
66.
My case, my lord, today it must be heard, my lord.
My lord,
He's
the,
simply taking 3 weeks, 4 weeks time. my lord.
13% every, same matter.
my lord, the
Same
difficulty
matter,
is that,
Same matter, my lord.
my lord, the difficulty is that since the connected matters, we are not getting the file since the party in person is moving frequently.
They are,
This 3
they have
weeks time
taken
is.
stay against
assured.
3 writ petitions
Let
by
us see
taking,
what is it.
filing 1 appeal, my lord.
At the time of hearing, we'll consider what to do.
My lord, the other connected matters notice also has to go, 66.19.
Let this be considered and see what to do there. Yes.
My lord, serial number 17, my lord. I appear for appellants counsel. May request short accommodation.
25th of July.
My lords, I appear with the serial number 29 for the petitioners, my lord. I need some accommodation to engage senior counsel.
6th of June,
My
6th
lords,
of August.
Serial number 25, my lords. We request 3 weeks time, my lord, serial number 25.
6th August,
Please, my lords.
August, first week of August.
25, my lords, it's a contempt initiated by the State Election Commission.
This was by the State Election Commission.
For what contempt?
Lords,
For
they have given
conducting
an
of-
undertaking in December that the reservations to Jilla Panchayats and Taluk Panchayats will be issued. Lords, because elections are overdue for 3 years now. All the panchayats are under.
Taluk Panchayat and Jilla Panchayat, my lords, notice was issued on the last date. My lords,
2 weeks will grant.
please.
2 weeks here, the Lords, Learned Advocate General requested 2 weeks. 2 weeks, my lords, is fine.
11 July.
Grateful, grateful.
My lord, serial number 47. Serial number 47, my lord.
40.
Appearing for accused. My lord, appearing for accused, my lord.
Serial number.
Serial number 47, appearing
47.
for accused, my lord. My lord, my senior is not well, so please give me a short date, my lord.
22nd July.
Much obliged.
Your lordship, serial number 19, your lordship. Appearing for the complainant, your lordship, the advocate of the government has filed the compliance affidavit. Kindly 2 weeks time may be given for filing the objections regarding that.
Office of the. Let it be called out. Compliance service is fine. We'll see. It is called.
So contempt matters, seal number 1, Mr. Mahesh M.
Your lordship, for the complainant. Lordship, in this matter, this honorable court had ordered the kata to be registered in the plaintiff's name, your lordship. If I may take this honorable
What direction?
to page number 16, your lordship. Your lordship, the order basically states that the kata has to be
Where is the
registered.
directions?
Your lordship, the direction is for the kata to be registered in my name, in the plaintiff's name, and in the,
Where is that? Read it.
your lordship, I would point out to paragraph 3, if I may. It
Read
says it is an undisputed fact that petitioners are the owners of 10 ankanas of land and property bearing Ganja number 580, assessment number 561 and 562. The petitioner's grievance is that the second respondent by the impugned order has restricted their claim to the extent of 8 ankanas of land. However, the perusal of impugned order passed by the respondent number 2 indicates that the Gram Panchayat concerned is required to maintain kata in favor of the petitioners to extent of 10 ankanas and further remove the encroachment made by the petitioner over and above 10 ankanas of land. I do not find any illegality or infirmity in the order passed by the respondent number 2. Your lordship, and further it says it is made clear that the petitioners are entitled for re-registering of kata in respect of property in question to an extent of 10 ankanas of land.
There is no direction which can be enforced. What is to be enforced?
Your lordship,
contempt.
here,
In contempt jurisdiction, what is to be enforced?
your lordship, now this is a direction for the re-registration of the kata in my name, your lordship.
Nothing.
My lordship,
Notice
I'll be
it.
left remediless if this.
Notice returnable on 22nd July.
Seal number 2, Mr. Chetan Kumar.
Complainants. This is a case.
Notice
where, Lord,
returnable. Settlement.
No, Lord. An undertaking was given to the court stating that the.
Where is that? Where is that undertaking?
Lord, annexure B, Lordship may kindly take.
Annexure B.
Annexure, Lord, B and C are the affidavits filed by the petitioner. Your Lordship's find, Lord, annexure C at page number 15. This is the, my Lord, affidavit filed by, my Lord, the accused before your Lordship's, my Lord. Can I request my Lord to kindly come to page number 15, last para there, para number 3. I state that after filing the above regular first appeal, the respondent and I have come to consensus and agreed to settle the dispute, and in pursuance of the same, I undertake to vacate the premises on or before 28/2/2024, that is 14 months from 1/1/2023. Then, my lords, I will request your lordships to kindly skip this para number 4, because in respect of para number 4 also a contempt had been filed. Only on filing contempt, my lord, he paid the arrears of rent. Then last para, the fifth para, I undertake to pay arrears of rent as calculated by the respondents and.
Notice returnable on July 19th. Please.
Number 3.
Appearing for the complainant. Lord, the direction
Notice
is to
returnable
consider
on
the
25th July.
Number 4.
Isha S. Kumar, party in person.
Good morning, my lordship. My lordship, I'm the complainant herein. My case is against my husband, who's the accused. There was a direction from the Honorable High Court in an MFA matter, which is yet pending. The order is there on page number 24, if I may take your lordship to. And there was a direction from the lordship in this matter, giving me, if I may be allowed to read the order.
So protection is not provided.
No, protection has been provided. My husband has cut off the water connection and the electricity for the house, as well as he's changed the gate numbers. If the order is seen, there's a gate number 3 and 4, which I've given access through by this honorable court. He has wantingly changed the gate numbers. The photos of the gate numbers is at, 1 second, page 188, my lordship. Especially after the order has been passed, he has changed the gate numbers, reducing my access.
Gate number.
The gate numbers for my access. It's a premise. The sketch is there on page number 186. If my lordship may kindly look into page 186, which shows the access to the relocated house. Now, this premise relocated house was provided.
You want to reside in the same property?
Yes, it is my premise. The order clearly says that there is
Why
no.
this is that provide protection to the respondent?
My lordship, we are not allowed.
Kindly listen. In the
Sorry.
event she desires to reside in the property.
Because my lordship, from 2011, I was staying with my husband in the matrimonial house. If the sketches looked at it, it's a.
How you want to reside there?
Yes, I want to reside there because I don't have a house.
So you applied to the commissioner for protection?
Yes, I have approached the commissioner.
After this order?
Yes, after this order, he provided me protection, but after
Who will
propose.
appear?
Pardon?
Learned additional government advocate, Ms. Nilofar Akhtar, is directed to accept the copy of this contempt petition. In turn, to take instructions from the Commissioner of Police, Bengaluru, as to the kind and nature of protection provided to the complainant in respect of the residential property where she wants to reside, which is bearing survey number 315/1 of 1B2 with accesses to the property through gate number 3 and gate number 4. Paragraph. The allegation is that the respondent has been obstructing the entry and the residence of the petitioner. Put upon 3rd of July.
Notice to the accused also.
As good as notice.
Much obliged.
Please. In order to enable learned additional government leader to seek the appropriate instructions, the Commissioner of Police, Bengaluru, shall be made party respondent here.
Much obliged, my lordship.
Amendment in the court status will be carried out by learned party in person in course of the day. So you add the party. Commissioner should be the party, you add it.
Yes, ma'am. I'll amend it. Much obliged, my lordship.
This is number 5. Mr. BC Venkatesh.
Not the direction is not at page number 17.
Notice returnable on 26th of July.
So number 6.
I appear for the complaint.
B.S. Nagaraj.
The directions of this honorable court at page 23. The mandamus is issued to respondent number 2, page 23.
directed to remove the fencing which has been put up by the property of the petitioner.
So notice returnable on 25th of July.
Serial number 7, Mr. Devarajan.
Appearing for the accused, my lord. My lord, the present contempt is filed against the interim order, my lord, granted by the learned single judge. I filed the statement of objections and also application for vacating stay. It's moved before the learned single judge. May I request for 2 weeks' time, my lord, contempt may be listed thereafter.
Stay was granted, interim order was granted in the month of April, my lord.
Since learned the respondent has filed application, has filed the statement of objections and also statement of opposition with a prayer to vacate the interim leave. This contempt petition is not required to be taken up at this stage. This contempt petition is adjourned to 5th of August.
Obliged.
Application matter, serial number 8.
Appear for the petitioner, my lord. But this is the matter, my lord, wherein the petitioner was removed midway through the course after 7 months of the course, my lord. On the ground that.
NEET and Ayush.
Yes, my lord, AIA, PGET. The 5% lower notification is at annexure D, my lord.
Yes.
Appearing for R4, your lord, to be
Alright.
R1 and 2, your lord.
All the respondents have been served on 19th June itself, my lord. I've produced the acknowledgements also. I produced the acknowledgements, my lord. All the respondents have been served on 19th of June itself.
You're not appearing.
I'm appearing for R4.
R4.
Aish. Relief is against R1 and 2.
Department of Ayush. Is the contesting word?
No, we are
My
not.
lords, R2 has issued an order to R1, my lords. R1 is the college, R2 is the Rajiv Gandhi University, my lords. So based on the department, the Ministry of Ayush, my lord, they issue a notification as per annexure D at page 25, my lord. My lords will find annexure D at page 25. There is a notification reducing the percentile by 5% across all categories, my lord.
So when the internal assessment examination?
At the end of the month is what I'm told, my lord. They're not issuing the notifications to me, my lords, because I have been removed.
We wait for day or two.
I'll lesser time. I'll seek this.
The difficulty is, my lord, one side of it is.
Are they served?
They've been served on 19th. I've produced the acknowledgements also, my lord.
Learned advocate Mr. Suraj stated that all the respondents are served on behalf of full stop. This number 4. Learned.
R4.
Learned.
Mamta Shetty.
Additional government advocate.
Yes.
Lords, for R2, my lords, I've served advocate.
For the rest of the respondents, have not entered their appearance so far. To stop in order to enable respondent 2 and 3 to enter to appear and only for engaged advocate, further time is granted till 26th of June. It is the case of the petitioner as already recorded in order dated 19/6/24 that petitioner's urgency since internal assessment examination would start at any time.
Lord, this is
last week of June, 10 or to 26th.
I will just make one mention. This is a PG Ayush course, Lord. So every day there are practical courses. So she's missing the benefit. First of all, she is a student with slightly lower marks, Lord. On top of it, she's missing the practicals on a daily basis, Lord. Which
show your timetable that the examination is going on or is starting on tomorrow. Then we'll pass the order. You're just saying that at any time it can start.
As per the notification, Lord, which I've produced already, which is at annexure F, Lord's page 27. It says at para 10, Lords, at point number 10, IA may be conducted once in every 5 months, Lords, 5 plus 5 plus 5. The course started in December, Lords. The first IA has also not been conducted, Lords. So that they've said is scheduled to commence at the end of June, Lords. So that's why there is a lack of clarity.
Wait for day or two. What is the difference?
7 months I've participated in classes, my lords.
But
Now,
then let
now
them
suddenly on the ground that some other exam which I've not,
To tell that examination is beginning, that you are not telling specifically.
we checked the notice board also, my lords, nothing was put on the notice board.
Then tomorrow? Tomorrow?
I have served the other side, my lords. Council is here, my lords. R2 is the contesting respondent.
Yes, so.
My name may be shown, my lords, in the cause list. It was not shown. My name may be shown, my lords, in the cause list.
File vakalattam and name will be shown.
Please, my lords, I undertake to file.
So permit him to appear in the internal examination.
Please. My lords, the only issue here is only with respect to OBC, my
There
lords.
is
Whether
some error on your part.
My lordship may clarify that the cutoff percentile which was done by the apex body, it is for the state as well, my lords. It's applicable uniformly to everyone. It's not something like different for the state and different for the center. What we have taken is, my lords, since she's not a OBC of the state, in the Karnataka, she's not an OBC. She's a non-Karnataka student. For that reason, we have disapproved, my lords. We have not approved her admission.
That's not what is found in the order, my lords. In any case, what the order would say is 5%, your marks are lower than the NEET percentile, my lords, the cutoff.
Because the cutoff.
The exam that I have written is AIA PGET, my lords. They have verified the papers.
Any internal examination is going on?
Let's the 3 years course, my lords. It's a 3 years course. Right now, I'm not sure, my lords. I'll seek instructions for the examination.
Tomorrow.
Please.
His anxiety is that he may be prevented to, unless prevented in the internal assessment examination, he'll be outstayed without.
Also, if I can start attending classes, my lords, because every day I'll be missing.
Council is taking tomorrow at 11.
Please. At the top of the list, my lords.
Stand over to 25th of July, June. Name of learned advocate Miss
Farah Fatimi.
Francis will be indicated by the registry. Appearing for number 2.
Respondent number 2.
Right.
Tomorrow.
PL matter, session number 9. Mr. Vinayak.
For the petition, this matter, my lords.
Submission, my lords, for the previous matter. I'm sorry, my lords. For R3 may be necessary, my lords. Mr. N.K. Ramesh appears for R3, my lords.
I have
Because
served
the
him.
admission,
I have
let
served-
their names may be shown because they'll represent, my lords. So N.K. Ramesh.
So served.
I've served him, my lords, on 19th.
And R4, the Union of India, my lords.
They have entered. The government has entered up here.
What is the problem?
Lords, this is a matter of some irregularities which have taken place in the Upper Krishna project. My lords, the Karnataka Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, Resettlement Act provides for some compensation, jobs, and other perks, my lords. My lords, what has happened is a property
This
which
is
was
PA.
single unit has been converted to multiple units by including the names of R7 to R18, my lords. My lord, this is a modus operandi using which some
Notice
persons
it
name
on 6th August.
one request, if I may, my lord. One request.
Loan at additional 1, 2, 3. Below for us.
Obliged. My lord, one request, if I may, my lord. My lords, despite of the irregularities which are pointing out on metal spillages, the respondent number 4, SLAO is proceeding with the further distribution of funds and disbursement of compensation. Kindly, interim order of status quo at least may be permitted. Entire matter will stand in front of us if that
How?
compensation is going to be given provided to the persons who are not at all entitled to get money.
We do not. No interim order.
Serial number 10, Mr. Manjunath PV.
I appear for the petitioners in this case. Yes, my lord. But there is a city called Muskie, my lord, Muskie town in Thrissur district. Lord, as back as my lord 1994 and 2001, my lord, road widening was already done, my lord, to sufficient extent. Now, my lord, all of a sudden they have again, my lord, brought this proposal of, my lord, road widening again by 7 feet on each side, my lord. By then, large number, my lord, this whole area, my lord, that pertains to Ashoka Circle to Bashir Circle runs to about 4 kilometers. A large number of, my lord, properties will be affected at a time. In the notification, our survey numbers are not there. Lord, even specifying the areas also they have issued notification. We have filed object. They have not considered that. Even prior to that, we had filed objections to all the authorities. They proceed, my lord, to dig, my lord. They started work also beyond without the exact notification in this regard. 3A notification, my lord, is found, my lord, at page 198. As per the act, my lord, they are bound to specify the exact, my lord, survey numbers, my lord, properties and all. They do not do that, my lord. They have started digging the whole issue, my lord. NHI is the authority, my lord, which actually. Supreme Court, my lord, number of occasions said, my lord, unless property that specified survey numbers are shown, my lord, owners are notified individually, they can't take up the project, my lord. They have started digging the whole, my lord, photos they have produced. By then, my lord, 1/4 the city will be covered, my lord, main area of the city, my lord, town. Without following the procedure, my lord, they have been.
So what is the disaster to the people?
My lord, the large number of, my lord, what happens in the middle of city, my lord, 2 kilometers area, twice is already widened, my lord, by 34 feet. They want to again, my lord, 7 feet here and there, my lord. Number of properties will lost, my lord. And above all, my lord, in the preliminary notification 3A, my lord, survey numbers are not shown. Only, my lord, properties are shown. And the names of the parties are not shown. They are not accepting objections also, my lord. At the same time, they are proceeding to construct, my lord. We ask them at least to consider representation, my lord. That representation are produced, my lord. We have sent to all the authorities. They do not consider that, my lord. They are going ahead with the constructions, my lord, by digging the whole, my lord, building as hearings and all that area. Therefore, my lord, public interest. Page 169 is the representation, my lord. When we came to know about this, my lord, 1 week earlier in the paper, newspapers, We made detailed representations, my lord. They are not considered, my lord. Even to all the authorities we have sent, my lord. Page 169. So Chief Officer, Municipal Town Council, my lord. Then all the copies are sent to Union of India, my lord. Then this authority, my lord, they do not consider. And finally, my lord, they have given already work allotment to somebody, my lord. By then, our buildings will. Then pass on Supreme Court judgments, my lord, judgments on this line.
You want a judgment, then we'll give our judgment. Now, give that judgment, road widening. We will not interfere in this road widening.
My lord, one
And
thing can
you are outsider.
One request may I make subject to. Either, my lord, kindly issue notice to them, my lord, one aspect. Secondly, my lord, their representations are not considered even till date.
That you can go.
Would your lordship direct them to consider at least, my lord?
Representation also by the affected person.
My lord, that is page, my lords, page
not-
at 169. my lord.
It is not your representation. It is not your representation. It is by somebody else.
Public, call the public, my lord. 34 people. my
Why
lord.
you should come here?
They have, my lord, they
Let
have
the
made
affected person
representations.
come and stress.
At least let them consider representation. So I'll be, my lord, alternatively, at least I will be. Otherwise, what happens is, my lord, the
But
whole
Lord,
thing, my lord, they take
this is
law into their
petition
hands.
number one.
Then may I show Supreme Court judgments, my lord, 2-3 judgments I have, my lord. Where Supreme Court says, my lord, that unless, my lord, the properties are properly identified and notified, my lord, the acquisition should not go on.
They will raise objections, affected person, in the acquisition procedure.
Now, where can I do is they dig, my lord, if they start working, but difficult, 3 AM on notification
Then
they have made.
nobody from the affected class
No,
is
my
here.
submission is, would you lordship, my lord, 3 AM notification, they make preliminary. Unless final is made, I would not have come, my lord. Because they only, my lord, come on, my lord, the spot there and they are digging. If they continue, my lord, the work here, where can I go, my lord? Subject to, my lord, coming to your lordship's, my lord, request, my lord, at least. If they make a submission that they would not go further, I would not at least consider the representation, I think would be, that will be solved, my lord. If notice could be issued to them, authorities. If they decide, my lord, I will not. At least to that extent, I think our rights should be saved.
Sorry. 10618 of 2024. Lord Learned Advocate Mr. P.V. Manjunath for the petitioner and Learned Additional Government Advocate. Disney for Akbar upon service of who appears to assist the court upon service of the copy of the petition in advance. Styled as public interest petition. In the present petition, the petitioners claim to be agriculturist hailing from Musky town, from Musky Taluka of Rayachur district. What they operate. Is to direct the respondents to call for the records pertaining to the acquisition of land proposed for the purpose of road widening from Ashoka Circle to Basveshwara Circle at Musky, which is 2-kilometer area. It is further prayed to set aside the very initiation of the acquisition proceedings pertaining to the widening of the road of 2-kilometer stretch, said 2-kilometer stretch. It is alternatively prayed, paragraph 2, direct respondents 1 and 2 to consider the representation dated 19/12/2023 submitted by the affected persons of the area. It is yet another prayer made to declare that the average area covering about 1 kilometer out of 2-kilometer stretch from Ashoka Circle to Vasveswara Circle is illegal and unauthorized, and the possession is unauthorizedly taken. Full stop. The essential clearance is about the road widening. It is inter alia pleaded that the authorities have started constructing a footpath measuring 7 meters in width on both the sides of the 2-kilometer stretch of the road from said Ashoka Circle to Basaveswara Circle at Musky town, and that the construction is partially completed. It is to be noticed at the outset that the petition is filed by persons claiming to be agriculturist. Full stop. Admittedly, as avoided in paragraph 3 of the petition, it is filed on behalf of the affected persons. So the affected persons are not before this court and have not been advancing any grievance. With regard to the said widening of the road, most of widening of the road, in normal circumstances, is always for public good and public purpose and public good. Full stop. As far as the questioning of the acquisition is concerned and the allegation that part of the road is wrongly taken possession of, comma, it is always permissible for the affected persons to raise their objections before the acquisition officers in course of the acquisition. So the public interest petition is not entertainable. Paragraph. The decisions relied on continue by learned advocates to the petitioners are besides the point. Full stop. Widening of road or making of road or deciding the layout of the road are all functions of the executive. In Iran versus Union of India, which was writ petition number 5201 of 2024, the division bench of this court observed. Thus, then, court paragraph 5.1. It was observed that the concerns which may be addressed in the public and litigation are the WOs and complaints of the deprived class like bonded laborers, under trial prisoners, prison inmates, and such deprived class of society. First of the public interest litigation, it was stated, is not appeal or panacea for all wrongs. When the field is occupied, field is within the domain of executive, and the functions are to be discharged by the executive, a court would not normally and readily make inroad in the executive functions. Full stop. Road making and road widening is such executive functions. The full court would resist from interfering. Full stop. It was observed in so and so super. Thus, and paragraph 6 means it has to be observed that planning out the road, events, etc., up to fundamental rights. Paragraph. No case is made out for interference or for granting any relief in this petition. The petition is dismissed.
Lord, Your Lordship, observed that they are at liberty to, Lord, regarding their grievances, they may. I think Your Lordship observed at least, Lord, that their representations even.
Right, the above order, since at this stage request came forth from learned counsel for the petitioner, it is observed that the petitioners, it will be open for the petition to pursue the representation
very great.
before the competent authority. Then take that to that part
Yes,
only.
that will be the.
Why you are inviting such an order?
Your Lordship's order would not come, at least not that observation.
Then we'll simply say that.
Because, my Lord, individually, suppose if they want to.
If you want to pursue representation, do it. Full stop. In course of the submissions, learned counsel for the petition, Mr. Manjunath, stated that the petitioners would opt to pursue the representation that is so and so, it is there. 1912 to 23, already pending with the authorities in relation to the grievance. Full stop. The petitioners are permitted to raise and pursue the said representation. It shall be considered duly by
Very grateful.
the competent authority in light of the facts which may be raised, facts which may be submitted. However, this court does not express any opinion on the
Great.
merits of the petition.
Like,
The present public interest petition is disposed of accordingly.
in bench matter, number 11, Mr. Ravindra Gajanan Kulle.
Yes, Mr. This is kept for some orders tomorrow.
But in the meantime, my lord, my one submission, identical matters are posted on a different date in the first week of next month. Maybe taken up along with that so that I can also.
The same
because-
submission was made, madam.
Yeah, I'm-
This was heard.
Yes,
This matter was heard.
Yes, my lord.
It was
I am-
heard,
I-
kept for orders.
Yes.
So my only submit, I had already presented legal proposition and filed it in the registry. That
Only
may
for-
kindly be.
For want of time, we will be, I am not able to consider, so tomorrow. Tomorrow.
So,
Tomorrow in the first half will be taken.
Please.
But in the meantime, the legal proposition I have kept ready.
What is legal provision?
Because about Rule 8(2), first proposition, and also two provisos therein, as well also deletion of Rule 8(4), as also pertaining to Rule 8, which is identical with the first provision of Rule 8.
We will lay down legal provisions.
Please, my lords, but I would like to have this to be brought to the kind notice of this honorable court, my lords, before passing orders.
Yes. Tomorrow.
That's number 12, writ appeal matters, Mr. Rudra Papi.
Small measure of delay is there. We were not represented before the learned single judge because the advocate on record absented and we were not informed.
Notice.
Can there be a date fixed for it, my lord, so that I
Naturally,
can seek for an interim order, urgent interim order?
19th of July.
My lord, may I please take notice for respondents 2 to 5,
Granted,
please. my lord.
Once accept notice.
Like,
Delay, we can't consider except unless delay is gone.
Can be considered in the light of the averments made in the IA.
On that day, any other party is there?
my lord, private parties are
Private
there.
party.
ma'am.
So we-
Respondent number 1 and respondent
first they have to
number
be served.
6.
Number 13, Nagendra Kumar K.
For the appellant in the film, made an application to raise an additional ground.
For the respondent number 1 in the writ appeal and for the complainant in the contempt petition.
Essentially, with regard to a contractual obligation, the writ petition was filed. The additional ground which I want to raise by way of amendment is with regard to entertainability of the writ petition in a contractual matter, my lord.
Yes, what is?
The order as such is in respect of an agreement or a contract, my lord. We have sought for we have made an application to raise an additional ground that it's a contractual matter. Writ petition in the normal course, writ petition is not maintainable, would be the additional ground which we want to raise.
What was the contract?
Contract was, my lord, the respondent sugar factory. Respondent number 1 sugar factory had respondent 1 sugar factory had raised loan from respondent number 2 through respondent number 1.
Respondent two, who is respondent two?
I am sorry, appellant number 2 through appellant number 1.
So original petitioner company took some loan through Sugar Development Fund from IFCL.
IFCL.
What happened?
Agreement at that time stipulated 2.5% additional interest in case of default. That is actually a rule itself prescribes 2.5% in case of default. That rule was amended in 2012.
Loan was taken when?
Loan was taken in 2004.
2004.
At that time, the rule prescribed additional interest of 2.5% in case of default. That is also part of the agreement. The very same term is part of the agreement. Rules were amended. That would be page 111 with effect from 30th July 2012. It was 2.5% was substituted by 6%. Now a writ petition was filed saying the amount that is recovered over and above 2.5% should be refunded.
Learner single allowed.
Has allowed.
Third learner advocate, Mr. Swan. Yes. It is only 6% will apply.
My lords, great respect.
1984 Supreme Court 1415.
My lords, the
Different
learned single judge has considered the judgments. And in fact, the rules very
Consider it final.
specifically require,
Consider it final.
well, all that be that as it may, my lords may choose to admit the
What
matter.
are the directions? Let
On
us-
insofar as the stay, kindly permit me to say this.
Yes.
The whole amount of 6% was deposited while the matter was pending before the learned single judge is with them. They have the money of 6%. The whole of the loan stands discharged. Now they are still holding securities of mine worth 100 crores. Now they have no reason to hold securities. Amount of loan is fully discharged. Disputed interest is fully discharged. There is no reason to hold securities. They are not complying with the order of the learned single judge. To the extent of refund, if my lords were to take that may be held with them, but they should return the securities. Why are they holding? I cannot continue my business. 100 crore worth of securities, I can't deal with it. Full amount is discharged, full interest is discharged. If they're not choosing to refund it and this court believes that that money should be held with them, so be it. Let them not refund that 6% right now, but let them return the securities. My lords will kindly see the order portion of the learned single judge, the operative portion.
Third learned advocate, Mr. So and so for the appellant. And learned advocate, Mr. You are going to caveat.
For respondent number 1, no,
For respondent one.
on notice.
Learned senior counsel, Mr. So and so for respondent one, original petitioner. Learned single judge allowed the writ petition of respondent one by judgment and order dated 18th January 2023. Where is the prayer in the petition? What was this notice 4/10/18? Impugned notice. before learned-
Those notices were for.
Demanding 6% rate.
Demanding 6% interest.
The petition, in the petition, what was paid was to set aside notice dated 4/10/18 and 13/11/18, as well as 25/4/19, received by the appellant bank, seeking to recover the rate of interest at 6%, enhanced from 2.5% on the amount of loan advanced and remaining unpaid. Full stop. Loan a single judge. The full stop. The controversy in the background was that respondent, that original petitioner, that's respondent one here, raised finance from the appellant ICICI Bank through respondent two, Sugar Development Fund. Full stop. It is the case of the appellant that at the time when the loan was taken, it was provided that the default in payment of loan would attract 2% high additional interest. Full stop. This 2% high interest came to be hiked to 6% with effect from 30th/7/2012. Full stop. On the date of hike of the interest as above, the loan had remained unpaid and the default had continued. Full stop. Loan a single judge paragraph. While allowing the petition paragraph, pass the following operative portions, operative directions, and quote the directions. Full stop. It was one of the submission advanced by learned advocate, apart from contending that the rate of 6% would apply since the default was committed in payment of in repaying the loan and the said default had continued, the dispute was in the realm of contract, and that learned single judge proceeded to adjudicate contractual terms of between the parties. Full stop. A prima facie case is made out. Full stop. The impugned directions, impugned judgment and order, and the directions passed therein by learned single judge before that appeal is admitted to be listed for final hearing. It shall be listed for final hearing in the beginning from 12th August. Full stop. Impugned judgment and direction of learned single judge shall remain stayed.
My lords, there are various facets in the impugned order, which if it stayed, even the labor will suffer. The workers' union has been directed to be paid. I have discharged.
This is only prima facie.
My lords, great respect. Kindly hear me out only on this one aspect. While the matter is being heard, as far as the securities is concerned, let them say, even prima facie, they have a right to hold the security any further. If my lords were to decide against me, even then they can't hold the securities. There is absolutely no ground to hold them when the whole amount stands discharged.
File IA and then get it vacated.
My lord, that's the direction of the learned single judge. That is why I filed a contempt. Kindly decide my contempt, my lords. There is a direction by the learned single judge, irrespective of the refund of the amount. There are two aspects in this.
On the fundamental principle, we are with them that
Absolutely. Even if they succeed, my lords, my submission is even if they succeed, still my lords will have to direct the refund of the securities, because the money will not be refunded, but securities have to be refunded. The securities have to be returned. Kindly see the direction of the learned single judge and the reason for the contempt.
No, not
Kindly see the direction, my lord.
Which direction? Let us.
Under the operative portion of the order, the direction number 4. At page 41, my lord. The first
Necessary.
respondent shall issue necessary certificates within 8 weeks from the date of receipt of the copy of this order. This is a discharge certificate for the securities. Refund amount, my lords, is the first direction. Kindly see the direction on refund.
No, there is no, it is entirely stated. Yeah.
My lords, my whole business has come to a standstill. My securities are not there. I'm unable to deal with my own securities.
You file IA and make out exceptions.
Please.
Today, contempt is there. Contempt will not survive the order passed. You get appeal challenging the very order and the judgment and order of learned single judge having been stayed. So contempt will not survive
Please.
at this stage. Not survive at this stage.
Reserve the liberty to file the IA on the aspect because the contempt aspect has been, this issue is also raised in the contempt.
So nobody,
My lord will say reserve liberty to file the IA.
nobody takes away the liberty. Huh?
My lord, this is an aspect of one of the directions in the order in which the contempt lies. If my lord just to decide on the contempt, can you decide on my plea on
This said
contempt?
learned advocate for the respondent argues that direction number 4 of learned single judge puts the original petitioner to serious difficulties. However, presently, when the appeal is admitted, no exception can be made. It will be permissible for the respondent or petitioner to file interim application and make out a case on merits.
Great.
Cell number 14, Shakash VT.
This matter pertains to Lord's seniority between two professors of medicine in a government medical college. Both of them were appointed as assistant professors on the same day, 6/10/2007. Under the appointment letters, we were given 7 days to report to duty.
Like a pardon, your lordship, before the senior counsel starts. In the first matter, notice is not issued. If lordship can issue notice for us, in the first matter, notice.
Then both will take up together. Notice returnable on.
If my learned friend can
But you
take
are-
notice.
No, I will take for respondent number 5.
Appearing or asking?
790.
No, no, I'm appearing. I may be permitted to take notice.
It's a common order by the.
It's a common order. I will appear for that. In the connected writ appeal, I'm appearing. I'm just submitted.
You are indirectly very good, wonderful way of asking time.
It's not. See, I
What
supposed
do
to,
you want, today or any other day?
any other day, because I have to reach.
Fifth respondent, let my learned
I
friend.
will accept the notice because before the senior counsel starts, I.
Well, on which day?
Lots.
28th July?
Third,
My lord, I take notice for respondents 1 and 2.
22nd July.
public.
22nd.
Notice for R3.
Learned, so and so. You are, madam, you are
First and second.
1 and 2, my lord.
1 and 2 and council. What is your name, Mr.?
N. Jagdish Paliga.
For number 3 and 4. Both will be on 20.
15 to 17 are urgent. Number 18. Chikkana Gowda.
Your lordship.
22, 26.
So the same matter you mentioned.
Yes, please, your lordship.
What is the report?
Yes. The respondent accused have filed compliance affidavit.
So we'll issue notice. Notice is
Making
already.
serious allegations against
Notice is
the
already.
complainant. We already filed the complaint affidavit in this matter. But affidavit in this matter.
Take mic.
We have filed the complaints affidavit in this matter.
They will file compliance.
We have already filed. File a rejoinder to the statement of the compliance affidavit because they have made a wrong statement which are contrary to the records available with me. And they say that we have issued notice, they have not given the documents required. But I have got documents to show that I have served the copies on the other side.
But after the.
And
file-
they are trying to overreach the order of the city civil court and order of this honorable court. All these things are there.
They will file compliance for that only. Overreaching of the city civil court.
I require weeks time to file my rejoinder.
Before they file compliance, you.
We already filed the complaints in this. Nothing has been let, this honorable court directed them
Learned
to
counsel-
carry out the directions issued as
learned
per the
senior
city civil
counsel
court
for-
order.
You want weeks time to file rejoinder.
Please, my lord.
Learned senior counsel. Mr. So and so.
LS.
Raise a week's time to file rejoinder to the statement objects.
Please.
How the statement of is not filed. Therefore, request is rejected. Compliance is not.
Rejoinder I would like to file for compliance affidavit,
For
which is
compliance affidavit is
contrary,
not
which is contrary to the records. That's the reason why.
Complaint, yes, we filed the complaint affidavit, yes.
I thought you were asking.
No, we have filed the complaint affidavit, that's all.
Learned Council wants to file.
Only
the
week's time.
Compliance affidavit, send out to 23rd. Granted time. More time than you wanted.
Number 19. The NS Bhatt.
In this,
After considering my reply and my counter affidavit, you kindly see the order passed by your lordship on 6/3/2024.
before.
6/3/2024.
There is a writ appeal that is filed by the state in this matter. Writ appeal number 746 of.
Their explanation is virtually rejected in this contempt proceedings. Kindly see the order on 6/3/2024. Thereafter, they taken time stating that we will file writ appeal. But even then now,
This is the 10% hike.
yes,
Yes,
please,
Your
please, madam. Your lordship is observed.
Court managers. The state has preferred an appeal, Your Lordship. We have preferred a writ appeal, 746 of 2000.
Learned additional government advocate stated that the writ appeal is preferred against the same very order which is brought under the contempt jurisdiction. In that view, which is that appeal?
746 of 2024.
In that view, these contempt proceedings, THES shall be listed with writ appeal number
746 of 2024.
6 of 2024, 746.
Obliged.
Number 20, Mr. Keshav Bhatt.
Compliance affidavit has been filed.
Compliance is filed.
Please.
For objection. Madam, mandamus was issued, my lord, to consider the representation. So far, they have not considered. They said, my lord, they will file objections here. They have not filed.
Page 19, which page?
Please.
Endorsement is at which page?
Endorsement is at page
19 or
9
20? 22.
16, my lords. In
But
our
objection
copy.
copy is not served on me. madam.
22, my
Sorry.
lords.
Objection copy is not served on me.
No, compliance affidavit not so.
It is,
No.
You
They
served.
are not come. No objection copies. Your lordship may kindly grant me some time.
1st of July to be listed at Learned Council for Learned additional government advocate.
Pramodini
Pramodini
Kishan.
files compliance affidavit since the copy is given to Learned today only from a standard first to be listed at 2:30 at first.
Number 21.
I pay for the complaint.
Mr. Bhatt.
Even here, the compliance affidavit has been filed, my lords. Representation has been considered. It's at page 12. my lords.
So it is decided.
Lord, the thing is this, my lord, earlier there was a direction to the effect that there was an order passed by the authority. Now what the authority says that this document is a fake document, all that. Earlier order passed by the deputy commissioner itself is, they are not relying upon at all. They are saying that documents cannot be believed at all. On that ground, they have issued an endorsement. I am not disputing. They have issued such endorsement. Blood, there was earlier a direction and there was an order being passed by the authorities, competent authority. Now the very authority, the endorsement is being issued, stating that the earlier order itself is a fake document, all the things.
So challenge it.
Please, ma'am.
This is CCC number contempt petition number 372 of 24 heard learned advocate Mr. So-and-so and so-and-so. Learned additional advocate.
Pramodini.
Additional government advocate Mr. Pramodini petition for the respondent state and authority. The only direction which was required to be complied with passed in order of learned single judge dated 11/12/23 while disposing of petition was to decide was to consider, was to direct, the only direction which was to be considered by respondent 3 as per the direction issued by learned single judge in order dated. Okay. Full stop. It was the following direction. It was the direction for sorry. Learned single judge by judgment and order dated 11/12/23 while disposing of the writ petition directed respondent 3 to consider the representation of the petitioner and decide the same within stipulated time. The representation about the preparation of khata in the name of petitioner. The petitioner had purchased the land in question by sale deed dated 28/9/2006. In response to the notice of this court, respondent appeared and filed compliance affidavit in which endorsement dated 7/5/24 is produced, in which the representation of the petitioner's answer. It is stated that the petitioner is unable to establish the genuineness of his claim for want of acceptable documents, and that the records were suspicious. The original record of the grant was not available. Therefore, the entering of name of the petitioner in khata was refused, and the case was closed. Full stop. While some decision is taken pursuant to the direction of learned single judge, from it could not be said that any contempt is committed by learned single judge. As far as the merits of the endorsement is concerned, from it is always open for the petitioner to file appropriate independent proceedings to challenge the same on its merits, from respect of which this court does not express any opinion. The present proceedings are accordingly disposed.
Please.
You may be right that they have done a wrong, issued a wrong endorsement, but then you challenge it.
Please.
Hearing on applications, seal number 22. To Chandrana, yes.
My lords, I appear for the accused number 6 and 7, my lords. My lords, this is a matter pertaining to compliance, my lords.
This is about contempt. Yes.
Please, my lords, your lordships have heard it on earlier occasions also, and the counsel for the complainant did not come. I have a difficulty in this, my lords, for which I have filed an application seeking direction My lords, the complainant has sought implementation of an order of the learned single judge asking to pay salary, etc. My lords, thereafter, I have calculated the salary that is payable by me, which is in my counter affidavit at page 5. My lords, for this amount, I have already deposited a DD, which this honorable court had permitted.
You have deposited.
Yes, I have deposited a DD.
So you are the
I'm the
employee.
accused.
Employee.
I'm not the employee. I'm the school, the institution. The employee is the complainant.
Where is he?
My lords, this is the second date. He has
Time
not
also
come. Please, my lords, I have some difficulty. I require approval of the state government to recruit teachers because I'm an aided institution. I've got an endorsement saying that on account of pendency of this petition, they cannot grant approval, my lords. Therefore, I filed an
You
IA.
have deposited some amount towards.
I have deposited both amounts, 2 DDs.
So then giving sanction to them to recruit, what prevents you?
The only thing is that
You and the school petitioner or complainer will not come in picture. But you can proceed to give if you are satisfied about the deposit of the amount.
yeah, let them give a representation to the state
My
government.
lords,
saying
I've
that they
already
have
given,
deposited the
kindly see
amount.
the endorsement. Kindly see the endorsement in my IA.
Time when the learned, this is the second time.
Yes,
At least the second time. When learned. It is at least for the second time that learned advocate for the complainant was not present and his presence was awaited in vain. Full stop. They when the proceedings were taken up, learned advocate for this one number
6 and 7.
6 and 7.
Please, my lords, I appear for 6.
Miss Nayan Tara pointed out that, submitted that Nayan Tara appearing for the respondent school, submitted that the areas towards the salary payable to the complainant has been deposited by the school with the competent authority. Full stop. He submitted that, she submitted that one of the direction in the order of learned single judge got to be complied with, reads as under, and direction number 2 on page 20, if the respondent 6 and 7 failed to comply. It was submitted that though the school has complied with the direction by depositing the amount, and there is a substantial compliance, comma, because of the pendency of the
Please, my
contempt
lords.
petition, comma, the authorities have not been issuing the no objection to the process of recruitment.
Please, my lords.
Required to be undertaken by the college, by the school, to fill up the post of teachers.
Please, my lords.
Full stop. The court prima facie views that this is a matter between the
School and
the competent authority. Full stop. Even as learned advocate for the petition is not present, it could be directed that if the respondent college makes a formal application to the competent authority with regard to seeking permission to recruit the teachers, same shall be considered by the authority in accordance with law. And in light of the fact that the arrears towards the salary of the complainant teacher has been deposited and that there is a substantial compliance of the directions of learned single judge. Full stop. Stand over to 24th of July.
Please, my lords, the interim order may kindly be extended.
Interim order, what is interim order?
The interim order is against the state not to take coercive action against me.
The interim order already operating shall continue to operate till the next date, till further orders.
Very well, I'm deeply grateful.
Case number 23. The Divya H.N.
Deposit, the areas are deposited, and that the amount is lying with the registry of. What is it?
Serial number 23.1, my lord. I appear for the petitioners. May I make my submissions in 23.1, my lord, if your lordships permit me?
What is it about? Let us-
My lord, the matter lies in a short compass, my lord. Petitioner number 2 was admitted to the PG course in petitioner number 1 college. There was a mistake in uploading the name of the petitioner. Petitioner number 2, my lord, is one Bhavna.
This is that matter which was heard.
My lord, that is 23 was heard.
23 was her. It is regarding. the
UG.
UG undergraduate, MBBS.
That some name was forwarded and.
Exactly,
on
my
the
lord.
last date.
Yes, my
something.
lord, yes. In fact, 23.1, even within the last date as extended by the NMC, we have done it, and NMC agrees to what we have done.
Who agrees?
NMC, my lord, the National Medical Council now. They have agreed.
But now what is the stage of the course today?
My lord, insofar as PG is concerned, my lord, this petition number 2 has finished 1 year. And the exams, my lord, is one examination, I think once in 3 years.
But.
Final exam in 3 years, that's all.
You will be seeking, even if you are succeeding, you are seeking the admission in the middle of the course.
I'm sorry, my lord.
Even if you succeed, your admission will be in the middle of the course.
No, my lord, she has already been admitted. She is attending classes.
Already admitted.
Yes, my lord. She was admitted at the beginning of the academic year itself.
Then
22,
what is
22.
what is the difficulty?
My lord, the difficulty, my lord, is that the KEA, the Karnataka Examinations Authority, must now put the name of petition number 2 in their portal as the candidate who has been admitted. That is all that is required to be done.
So you are studying, admitting, attending classes, everything.
Exactly. My lord, don't difficulty about all that. And in fact, the student, my lord, whose name is wrongly entered, has also given a letter saying, I am not interested. And she has got admission in the subsequent year in a different institution.
So what about 23?
23, my lord, undergraduate, MBBS.
So different.
Same college.
So we are dealing with.
It's the same college, my lord. I'm sure some confusion.
So why it is tagged together? If it is.
My lord, there is no need to tag it together.
No
my lord,
need.
there.
Ah.
No need, my lord. According to me, there is no need to tag it together.
So we will start with 23.1.
We start with, yes, my lord, if your lordship will permit. My lord, petitioner number 2 was granted admission, my lord, on 2/12/2022. We are concerned with the academic year 22-23. And this pertains to, my lord, the PG course. As a candidate, my lord, she was admitted to the MS, obstetric and gynecology. Instead of last date is undoubtedly, my lord, 2/12/2022. There is no doubt, dispute about that. In fact, the last date has been extended to 14/1/2023.
41/20.
14th of January 2023. Your lordship will get that, my lord.
Last date for admission.
Yes, my lord. Your lordship may kindly turn to annexure L so that, my lord, your lordship gets all these facts, and then I'll make my submission. If your lordship will be kind enough to turn, my lord, to page 56.
The 55, my lord, is the communication from the National Medical Council. May I place that for your lordship consideration, my lord?
Yes.
As per the approval accorded by the MOHFW, that is Ministry of Health and Family Welfare, Medical Counseling Committee of DGSL will conduct a special stay vacancy round for the vacant PG, MD, MS diploma, so and so.
Where you are reading?
My lord, I am reading at page 55, my lord.
50. Yes.
Annexure L.
Yes.
As per the approval accorded by the Ministry of Health and Family Welfare, Medical Counseling Committee of DGS will conduct a special stray vacancy round for the vacant MG, PG, MD, MS, Diploma, PG, DNB, MDS seats of All India Quota, Central University, Central Institute, Deemed University of PG, DNB in an online mode. Last date of admission is 14/1/2023. We are not concerned with that, my lord. I must tell your lordship straight away, because this is nothing to do with the allotment of seats on All India Quota, Central University, Central Institute, Deemed University, PG, DNB. We are not concerned with any of that. Then, my lord, please be kind enough to turn to the second paragraph. Since Medical Counseling Committee is in receipt of representation from several states regarding extension of last date of admission for PG Counseling 22-23, the competent authorities have decided that a timeline for AIQ counseling and state counseling could be on the same line. That is where we are concerned. Therefore, all state counseling authorities are hereby informed the last date of admission counseling for state quota is extended till 14/1/2023. That is what we are concerned. So, because in respect of one category, they extended it to 14/1, they said it will apply to other category also. That's where. And now, my lord, please be kind enough to see page 56. This is, my lord, the communication issued by the Karnataka Examinations Authority, the KEA, on 10/1/2023, indicating, my lord, that in furtherance of the MCC notice issued by Government of India, Directorate of Health and Services, and New Delhi reference number so and so, details are given below. Last date for admission at the college for names list allotted seats 14/1/2023. Therefore, my lord, the controversy as to whether you admitted the student before 2/12/2022, all that pales into insignificance because the admission date has been extended. The last date was extended to 14/1/2023. Now, my lord, kindly see Annexure E, my lord, which your lordship gets. At page 41. This is a certificate, my lord, issued by the college. That is petitioner number 1 before your lordship, to say that Bhavana T, that is, my lord, petition number 2, is provisionally admitted in the first year MS OBG under management vacant private quota subject to admission criteria of the Rajiv Gandhi Health University, policy of the state, DME NMC. Now, my lord, your lordship may kindly turn to Annexure N, my lord.
Now, here I have seen in more than one petition. Why the institute is also becoming petitioner along with the petitioner?
Well, the institution is becoming a petitioner along with the student in order, my lord, that there should be proper record. Otherwise, my lord, what happens is tomorrow there will be a difficulty in getting the hall ticket for the examinations, announcement of results, permitting them to. So, my lord, the institution, instead of a respondent supporting the petitioner, but we are placing the facts before your lordship so that we also my lord, state and support that the petitioner number 2 was admitted to our institution. And we are, my lord, the persons who have communicated with the respondents to say, please put the name of petitioner number 2 instead of the wrong name, Chaitra.
So what right number 1 is enforcing?
My lord, I would say, my lord, it may not be a right. But I am entitled to have, my lord, I am entitled to say that the records of the authorities should reflect the action which I have taken in admitting petition number 2 as my student.
Very well.
I will put it that way, my lord. My lord, your lordship will be kind enough to see annexure N, my lord, now. Well, may I read annexure N, my lord? That is 12/1/2023. Regarding the aforementioned matter, I'm sorry, my lord, annexure N would be
61.
yes, my lord, page 61. I'm grateful. But this is the letter of petitioner number 2, who says, currently I am not interested in continuing the course of MS OBG in Srinivasa Institute of Medical Sciences and Research Center, Bangalore, due to personal issues. Kindly cancel, remove the name of your portal. So, my lord, she is not interested. In fact, she has got an admission in another college in the subsequent year. All this Chaitra, the student whose name was wrongly reported, Chaitra, has got an admission in the subsequent year in another college. And your lordship may kindly see, my lord, that there is a list of candidates admitted to all the colleges as published by the NMC. And in fact, my lord, I want your lordship to kindly see annexure J1 also, my lord. That is a very important document.
No, but why they are not adding the name on your name on the portal?
My lord,
On the ground that your evidence is subsequent to the last.
subsequent. They say, no, you are trying to manipulate. You are trying to say.
So then show that your admission was before 14.
Yes, my lord. First, my lord, I am showing that in fact there is a receipt given for the payment of the fee.
Let us.
Yes, my lord. My lord, kindly turn to annexure E1 at page 42, my lord, if your lordship is kind enough.
Two 12/22.
Yes, my lord. That's last date. And I showed you, lordship, my lord, the NMC list also contains the name of petitioner number 2.
So any allegation about any other irregularities?
No, my lord, no other irregularity. All they're saying is, look here, how we are not going to entertain the name of petitioner number 2 because we think the admission was made subsequent to that date. Subsequent to 212. I am saying, my lord, today the 212 becomes irrelevant.
College prepared a backdated receipt.
Yeah, that's what they're saying. And today, my lord, 212 becomes irrelevant because its date has been extended to 14/1/2023.
Earlier it was?
212, last date.
212.
Yes. And I showed you, lordship, my lord, that even in the web portal of NMC, the name of petition number 2 is found. If your lordship will be kind enough to see, my lord, annexure X. Annexure, your lordship may kindly see annexure J1 first, my lord. Lord, kindly see annexure J1 if your lordships are kind enough. This is published by the National Medical Commission. And in respect of this, my lord, there is not a whisper in the statement of objections that has been filed by the National Medical Commission. Kindly see, my lord, serial number 6 at page 650.
Page?
50, my lord.
Page.
Well, this is on the website of the NMC. And your lordship may kindly see the college name, my lord, petitioner number 1. Course, my lord, MS Obstetric and Gynecology, State Government University, private, etc., etc., academic year 22-23. Seats displayed at NMC website. 6, last date of admission 2/12/2022.
This is published by?
NMC, National Medical Commission.
National Medical?
Commission, my lord, NMC.
Council?
No, my lord, it's now called National Medical Commission. It has replaced, my lord, the IMC, the Indian Medical Council. Now, my lord, there's a new enactment under which, my lord, the National Medical Commission has been constituted, which replaced, my lord, the old IMC.
I have lost my touch with the educational method.
I mean, but it's changing.
In earlier days of practice and elevation,
It used to be IMC, my lord. Now
later
it's,
on not.
now it is NMC.
Therefore, I have kept this, so that I know something about it. Yeah. Yes,
But kindly see serial number 6, my lord, in that.
yes, I have seen.
Kindly see the name, my lord. Bhavana.
Yes.
That is petition number 2. And in fact, in the list of, they also not only do this, they also give us a comprehensive list of all students admitted in all the medical colleges in the state. Even there, my lord, petition number 2's name is there. None of this is, that my lord, your lordship gets, is part of annexure X, my lord. Is part of the affidavit filed on 4/1/2024. Sir, go to sir. And this annexure X, and this annexure X, my lord, came up on 14th of June 2023 after the writ petition was filed also. Yeah. Well, this is the entire list, and your lordship gets that typed copy, my lord, at page 21. The relevant portion we have typed, my lord, there are a number of students. It's so difficult to read it also, my lord, because it's a small font. I apologize, my lord. Kindly see page 21. Bhavana's name is there.
Sorry, no.
Your lordship gets page 21, my lord, annexure X, the typed copy. Your lordship may kindly see, my lord, Bhavna. MS, OBG.
This is a list of common list.
Yeah, this is a common list. And then, my lord, I also want to point out, your lordships, that this Chaitra has got an allotment letter from NMC.
So what is the significance of this other student?
I'm sorry.
What is the relevance of this other student, Chaitra?
But other, because what happened, my lord, was when we sent the information on 212, by mistake, my lord, we put the name of this Chaitra instead of putting the name of Bhavana. Thereafter, we immediately corrected it. I said, no, we made a mistake. It is not, it was a omission, a clerical mistake that is taken.
Even if it was a mistake, what is wrong now?
No, it's not a mistake.
The
sir.
other,
It's not a mistake.
other petition number 2 is regularly
No, first,
within time admitted.
no, madam. First and foremost, there should have been a vacancy for admission of the petitioner. Second petition, first petitioner. There was no vacancy as on the date, my lord. What had happened, your lordship, I kindly take my statement of objection.
Your statement.
Yes, I have filed a statement of objection. NMC also has filed a statement of objection. Once the admission, well, 212 admissions are over, but we are supposed to upload the,
It is
upload the,
your statement means affidavit of.
that is
number one.
dated 7/3/2023.
Which one?
Second petition. Third respondent.
17.
It was not,
7th.
so filed on 7th.
7th.
Plus you got it.
Paragraph 3 is important, my lord, here.
Yeah. I have.
Why you doubting the stand of Chaitra and everybody?
Chaitra's admission was given, her name was uploaded to us. Lordship, can you see below the annexure R2? Along with this is R1 is not the statement. The Chaitra's name is uploaded by the college, very well it is there. Before the last date. And my lord, your lordship may kindly see, my lord, the.
But they were within the right to cancel the admission of Chitra or not?
No.
Rightly or
No,
not?
it has already uploaded. Admission has already given, they have taken the.
Can't be cancelled there.
No, they cannot cancel.
Why?
But the admission given, once it is uploaded, they cannot cancel. There is no seats.
Chitra wants to back out from the course.
It is not the case that they have cancelled the admission.
Not interested in continuing the course of so and so. For my personal reasons.
That your lordship can see when that application, that letter was received. That letter was received on 9th, 13th January. By the time admission process was over as far as.
It was 14-1.
But there was no cancellation. She is not before the court.
Seat would go waste.
This is, well, seat may go waste, but this is a case of seat blocking. This is a case of seat blocking. That is where, we are concerned.
We difficult to read all these things. You may be right. How should we read? Should we read positive or negative?
But she takes an admission. Her name is uploaded to us, uploaded to the NMC as well.
Why you want the court to read things which are negative?
No, because the seat, this is the last seat. All admissions were given.
So what is the violation?
The
violation of what?
Violation not the regulations of the NMC, where it has to be given on merit. And when the admissions are over, as per the calendar 212, all 50 admissions were over. They should have come back to the KEA saying that she should have the college, either the college or the candidate who withdrawn from the admission. She should have come and gave a letter.
What amount was paid by Chitra?
75 lakhs. 75 lakhs.
This petitioner?
This I do not know about that. I have to say.
From 22, page 41 is the receipt. What is the amount paid? That is
10 lakhs fees. In fact, that 71 lakhs, my lord, is a pro forma. In fact, if there is I must say, my lord, there has been mistakes committed by the college. I am not running away from that. And the fact of the matter, my lord, is that Chaitra has been granted admission for that subsequent year in a new institution, in a different institution. My lord, nobody is suffering by this, my lord. I see why. And NMC, my lord, has issued a notification saying.
Then therefore we asked the question from the beginning, why college is part?
Why?
Why the college is also
College is a party, not because we made a mistake. We wrote to the KEA, change it. They did not do it. Therefore, we are before your lordship. That's all.
They are saying that you are broking the seat for money.
No, my lord, we are not. The point, my lord, is this: that one seat I am entitled to fill up. There's no dispute about that. 14th of January 2023 is the last day. Even if whatever I do up to 14th of January is legitimate. There's no difficulty. And in fact, my lord, NMC has said, I give 2 days beyond 14th even to rectify mistakes. There's a communication with NMC. I showed your lordship that. 1 minute, let me complete if you don't mind. If I may be wrong, but let me say what I want to say. And I ask myself, my lord, if NMC themselves have said that the student Chaitra has got admission for the subsequent year in a different college, my lord, what is the harm that is being done? Today, my lord, what is the position that happened? Bhavna will lose her seat. Let us take the best for the authorities, my lord. Bhavna will suit the seat. Chaitra is not there. 1 seat gone. What's the purpose? What's the purpose of it? That's all that's going to happen, my lord. Ultimately, that's what, not that Chaitra will come back. Because 1 year is over now. And Bhavna has been attending classes for the last 1 year.
So what fees you charge from this number 2?
My lord?
What is the amount of fees you charged from Chitra and for number 2?
My lord, I think there's some, how much is it? No pay. Not exact amount which they are charging, my learned also does not know. But in any event, my lord, the 75 is a figure in the air.
70?
75 lakhs is a figure in the air.
From whom?
My lord?
From whom?
They are the allegation, my lord, is that 75 lakhs has been charged from Chaitra. Not so, because your lordship may kindly see that receipt. It's a pro forma receipt given by them. My lord, I must confess that it's a mistake that has been committed by the college.
Dean has signed it.
It's a mistake. I agree. There is no doubt about it. I mean, I'm not running away from that fact. But mistakes can happen. And please be kind enough to see, my lord, Annexure J at page 41. Please see Annexure J at page 41. May I trouble your lordship to kindly see, and this is expected, my lord. At page 47, my lord, I'm sorry. Please see page 47.
1 second. Page 47.
Please see page 47, my lord, if your lordship is kind enough. This is a communication, my lord, from the National Medical Commission.
From?
My lord, that is a communication from the National Medical Commission, and what is relevant for your lordship's consideration, my lord, is
which statement of objection?
No, my lord, petition.
Page number is.
Page number 49, my lord. Page 49. It begins at page 47. I am at page 49 of the petition, my lord.
WP 1565.
1565. Sir, court officer, sir. 1565.
So we are dealing with which? 1560.
Yes. No, no, your lordship may kindly see 1565. That is 32.1. No? 23.1. My lord, would your lordship be kind enough to turn to page 47, my lord?
Yes.
May I trouble your lordship to kindly see page 49? At 49. Kindly see para 10 at the top of the page. Kindly add the details of the students according to the fields as mentioned above, which will be available on the screen. Provision has been given to modify or delete any wrong entry within 2 days of last date of admission to broad and super specialty courses.
So this is part of some communication.
Yes, my lord, it is part of the communication issued by the National Medical Commission. They do recognize all the time pointing out here that there can be a minute. My lord, what happened was 2/12/2020 last date, and then my lord, there is a mistake in uploading the name of the petitioner. There are, and promptly, my lord, we wrote to the authorities saying there's a mistake, please correct it.
So cutoff date is the date of admission.
Cutoff date is 14/1. And if your lordship will kindly see, my lord, so far as Chaitra is concerned, she has been given admission in another institution, and that is recognized by the NMC also.
Very well. That is your case. Yes, what is to be done?
Only one thing will I have to show. My learned friend is saying it's a mistake by the college. College may have a mistake, and the student also, she does a mistake. Your lordship, I kindly see, it's an online payment of 75 lakhs at page 7, annexure R3.
You are for college.
I'm for the KE, Lord.
Karnataka
Examination Authority.
Examination Board. Yes.
In the Chaitra paid 75 lakhs.
What is your name?
Ramesh, NK Ramesh.
Your senior advocate.
No.
Advocate. Is it? Yes.
She has paid the fee voluntarily. Chaitra, she got herself admitted. She paid the fee online. Online payment, the nodal officer has this thing, page 7 of my counter. So the Chaitra's admission as on 2/12, that was the last admission, my lord, of the college, was complete. 150, I'm sorry, my lord, there were about, this is a PG, my lord. All the PG seats in that college in MS OBG was complete. Six seats were there, my lord. I mean, in MS OBG. I said so, my lord, in my statement also. It's only on 9th.
Page?
My lord, page R3 at page 7, my lord, is the online application. Online payment, lordship, kindly see this. Payment mode. I've produced only 3 documents. One is, my lord, the uploading of Chaitra's name. That is at page 5 of my statement of objection.
The paging is not, I'm not attuned to your paging. To change the paging. Paging in this High Court needs to be changed thoroughly. Yes, find out page 5 which the council is citing. Every time, every compilation, different page. No running pages. Difficult to find out, at least for me. We waste time like anything. And breaks the link of thinking, yes. Every compilation you tender has different paging.
Sorry, my lord.
We are going to change it. That is what I am proposing.
Yes, my lord. All in line with the court's.
Yes, it should be running pages.
Yes.
Without unnecessary additions in between. So what is this, page 5?
This is page 5, is the list of students uploaded by the college of the admission of Chaitra is there at serial number 34.
Serial number
34. Then, my lord, next is, my lord, the annexure R2 is the admission.
But then uploaded on what date?
That is, my lord, 2/12. 2/12. Last date is 2/12.
2/12.
2/12. Then, my lord, the next is the P payment. Also, they have to upload that they have uploaded.
Yes.
That is, my lord, annexure R2, page 6, is signed by the dean.
75 lakhs.
Yes. It's up to 212.
And they paid, according to you, they paid.
Yes, next, my lord, 75, yes, online payment by my lord Chaitra, page 7.
Correct.
This is the receipt generated by them, given it to Chaitra, uploaded it to us, it's online. This was countersigned by the nodal officer. So therefore, on 212, the entire admission process of Chaitra was over. And it's only on 912, she writes, my lord, 1312, she writes, saying that 13-1, 13-1.
13-1-24.
24, that is annexure N. 23. It must be 24, I think, Lord, because they have 23, yes, 13-1-23. Annexure N of the writ petition, page 61. So therefore, as on 212.
Before 13-1-24, they were never, you were never aware that.
No.
He is withdrawing.
No.
No, same on 212 itself we have written. On 212 itself we have written. Your Lordship may kindly see annexure H at page 46 of the writ petition.
46.
To the page 46. My lord, the moment we discovered it, my lord, whatever it wrote it at 23:52 to 8 minutes before the midnight, there is a mistake. So, my lord, on 212 itself, we have written. And they have received it. Please see page 46, my lord.
It is addressed to the Director of Medical
Yeah,
Education.
that's all right. The Director of Medical Education is the, and I showed your Lordship all the communications. We would like to inform you that the following candidate got admitted in our college on 212 with all required documents and KA verification, namely Bhavna. Due to network connectivity, our clerk inadvertently uploaded the wrong candidate name, Chaitra, in the KEA portal on the day, requesting to kindly do the needful and permit us to replace the candidate name and details. And I asked myself, my lord, if this was not a bona fide mistake, how did NMC put the name of Bhavna? NMC recognizes that. Page. And then your Lordship may kindly see page 52, my lord. 51. 51.
So according to them, only intimation is on 13-1-20.
Yes.
Otherwise, they had regularly admitted the petitioner and they were
That's what
in
their
know
case
that
is. That's
this
what
Chaitra
they,
was not going
So-
to.
yes, that's what their case. That's what their case is.
And,
Chaitra was-
and circumstances, my lord. Chaitra has got an admission subsequent year in a different college. And NMC recognizes the name of Bhavna petitioner number 2.
This is PG course.
It's
PG course, PG course.
Post-graduation.
So this endorsement in the middle on page 46.
Yes, my lord.
Acknowledgement rather. Acknowledgement.
Yeah, acknowledged by, my lord, the Directorate of Medical Education.
Director of
DME.
Medical Education.
By?
Directorate of Medical Education. My lord, KEA is an authority appointed by the DME to be the nodal agency for the purpose of conducting examinations and doing the counseling. Ultimately, everything is done under the aegis of the office of the DME. Yeah, reference number 0449. We are ಬೇರೆ ಒಂದು ಚೆಲ್ಲಿದೆ number. Was that? Summarize this one. Yeah. ಅವ್ರಿಗೆ ಬೇರೆ ಕಾಲೇಜಿನ ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅದಿಲ್ಲ ಯಾವುದು ಅಫಿಡೇವಿಟ್ ಪೇಜ್ 17 ಯಾವುದು ಝೆಡ್ ಝೆಡ್
Yes. Yes.
बन्नी हो रहा है।
getting a seat in the but Chaitra, as my learned friend put it, Chaitra getting a seat in the next academic year has nothing to do with this. Here, not the irregularities in the admission process by the college. The colleges, my lord, this is a my lord, modus which they adopt every year to thwart, my lord, the entire process. This counseling is against the unfilled seats. No doubt it's the management seats. Fees were high. But the Supreme Court, the NMC says all admissions should route through us. Unfortunately, last year it was not so. So, my lord, we have sent a list of students to the institution from which they have to admit. As far as Bhavana's, my lord, eligibility for admission, my lord, I said so in my first para itself, I don't dispute. But there should have been a vacancy for making the admission on 212. 212 entire process was complete. There was no, my lord, cancellation. They were written to, my lord, the DME, that's what they say. My lord. The DMA has to answer, my lord, whether he has communicated. Yes. That's it. They say wrongly admitted. Wrongly paid the fee also, my lord, by the student. That time I put that question to myself. No, we are not against not to give a seat to her. She is not a party also. They have not made her a party. P2. P2. She is studying. Studying is all right. At this juncture, I definitely, I don't say to go to that extent. But the college has to be penalized for such actions. Otherwise, this will recur every year. This will recur. Because the next, that is the reason what the other petition is tagged on to. Same college. Same.
My lord, I can't say all is well, my lord. I know, my lord, a lot of things have to be done properly. I agree, my lord. I know.
But the purpose now we have come to that, my lord. The last, my lord was wondering, what is the purpose behind this exercise at this stage? That is the thought running through my lord. But what is running through my lord? Right. It's like this. On the second, if a seat has been filled up already, the whole thing is about merit. It is not about the last one. Whole exercise before this court, my lord, what we are urging now is that merit has been given a go by. Merit, inter se merit, two words, inter se merit has been given a go by. That is the issue before the court, not the last day. Last day is only incidental. Consequence of that is more serious, and that is what we have before this court. I'll just read two small portions of two paragraphs, then I'll stitch together whatever my learned friend has said. Once again, from this perspective of inter se merit. Till now it was being obfuscated as far as last date is concerned, as far as Chaitra is concerned, her being in the next academic year. All that is all. That has nothing to do with it. Finally, see the two paragraphs, para 8 and para 10, 3 lines apiece. Para 8 of the reputation. I've extracted all this in my statement of objections as well. Please read it here. Para 8, page 10. Is at this stage noticed by the institution, the candidate, Dr. Chaitra Ji, has been wrongly entered in the column by mistake while checking for the eligibility of the said candidate. However, since the candidate, Dr. Chaitra Ji, having not wanted MSOPG seat at the petitioner institution, having not paid any fees, and having not been admitted by the petitioner institution. Three things are stated. Not wanted admission, wanted the fees, not having paid the fees, not having been admitted. They say three things have happened with regard to Chaitra. Now we'll see about that. Petitioner wanted to delete the name of Chaitra and to enter the name of the petitioner. That is repeated once again at para 10. That since admission was not granted, para 10 again, 6th line from below. That since admission was not granted to Dr. Chaitra, and that admission was granted to Dr. Bhavna P. So there was she not having wanted, having not paid the fees, and having not been admitted. These are three facts on which the petition is founded. We go back to, there will be one more document which will be forthcoming from the university. When we see that, that will address my contention there. Then we come back to the letter. We come back to the letter. Letter of the 13th of January. What does it say there? Currently, I am not interested in continuing the course in NSO. This is the communication from Chaitra, which has been produced by them. So now when this is the situation, what happens? The student says that I am now not interested in continuing the course on the 13th of January. What happens to the pleadings in para 8 and 10? Not admitted, not paid fees, not interested. So that letter which says I am no longer interested in continuing nails para 8. Because I am first on pleadings. Para 8 says pleadings also mistake, then I'll sit down. If it extends all around mistake, then I'll condone them. That's right. Therefore, now it is not. So, therefore, is this a mistake, or is this a pleading which is sought to? It's dishonest pleading before the court. Bluntly. What I'm trying to say now is this. What I said about inter se. So, what happened was, let me point out this also. What my learned friend also pointed out, but I would like to zero in a little bit more. But each eye sees it slightly differently. That's the beauty of our profession. Each one will point out from a different perspective for the court to accept one of the perspectives. Please take, once again, I'll cover the page. Luckily, not page 5, page 6, my lot of my letter. See, this annexure at page 6. It says admission has been made at what time and what date? 23:52. 8 more minutes available to admit Bhavna. For the clock to change over to the 3rd. Now, if this is the issue there, and on the 2nd, Chaitra has been admitted. Can we see the amount she has paid for it? There was some doubt about the amount for her. Figures are small, therefore all of us, these practical people, have a little bit of difficulty in reading it, but I took the effort a lot. Please see the number of zeros. It says 75,15,000. And this is under the signature of the same deed. But another letter was also shown to us. We do not wish to tear apart all letters and everything. But we wish to point out the same dean has said this and uploaded. This is what it says. At 23:52, 8 minutes before midnight, she has been admitted at 75 lakhs, 15,000. So what happens now? This is the inter se merit argument. On the second, which was the last date for admission, I have to point out this fact that subsequently the last date for admission was extended. But for what? Where there is or was a vacancy. Vacancy on the date which we have read and said that yes, on that date, all those places where there was vacancy, and as well Lord rightly should concern, so vacant. What is now? Little while. So they extended that date. But on the second, the last seat at 23:52 hours has already been filled up. There is no vacancy available. All other meritorious students, this is what happens at that point of time, my lord. All other meritorious students, my lord, who were seeking admission for PG course and did not get it, go to sleep in despair. That's the time to go to sleep for them, because the second is over. And it is then, and it is for this reason that merit is given a go by, a candidate's name has been entered. Now, how do they replace on merit the substitute candidate? So this is called seat block. And they will not be coming. People have to come. What has to be done is, they have to look at all the candidates who are on merit and invite them. And those who would be at their doorstep would have been told that, oh, this seat is filled. In fact, what is required and what we don't do is a thorough investigation into this and what happened at 23:52 itself. But we will not go into that because we have enough material available to nail them on this point. Point is this: once 150 seats are filled up, the next seat to be filled will not be a seat for which any student will be expecting to be admitted, therefore will go to that college. Nor will the college be inviting candidates to say, which one of you on merits, please come, there is one vacancy, we will evaluate your vacancy and then give you a seat. So it is that inter se merit which is given. And another person has been taught. How and when and all, by circumstances and facts, we are able to see that the candidate only on the 13th notifies that I am no longer interested in continuing. So it is on the 13th that a vacancy falls. Till 13th, 150 students are available. So now what happens on the 13th? For the second time, the inter se merit argument will be repeated. If they had come in all honesty and told the court, but they did not tell that because, for whatever reason, on the 13th, on the 2nd, when they did the general, after the second, they blocked this seat because that was the last day, so they had to block it. A name had to go up. If the name doesn't go up, this mistake argument, which is repeated in serial number 23 again the next year, which was there in the previous year in 23.1, should not have been available. Please delete it. So a candidate has to be there. This candidate has been put there, or the candidate has filled it up. Either case, but they did not know that circumstances will arise by virtue of which an extension of time will be done. So what they did is, their readings are, and they state that we have filled it up on the 2nd. So two things again happen. First, we are saying that 2nd already, Chaitra has filled it up, so Bhavna could not have been, she could not have been admitted. She becomes 151. Her 151 admission is discretionary. And therefore that is flawed. Therefore the penal consequences which I am seeking in my statement also. These are the consequences that flow from it. Then let us assume that all this had not happened. But on 13th, she writes a letter and says, I want to go. 14th was available. Till 14th, they could have made a right royal admission. But then, on the 13th, they would have to deal with 2 words in the same merit. Call upon candidates to come forth for admission. But then they have already said that I have already admitted her on the 2nd. So now they can't call anybody on the 13th either, because their argument is that they have already admitted her on the 2nd. So this is what we are trying to point out, not the fact that 1 day late or early. Supreme Court is very strict about this 1 day late or early, not because that 1 day late or early is important, because that 1 day late or early means all the rest of the crowd go to sleep. And inter se merit candidates who are aspiring for that will not be able to compete for that seat, because that seat is closed up. So on the 13th, they did not say we filled it up on the 13th, they would have been perfectly all right. But they said we filled it up on the 2nd, there's no vacancy. First floor, no vacancy, yet filling up. 151 in excess of the quota. That is wrong. And filling up in excess, no candidate, no student is ready for admission. And then about the but starting with Madhu Singh's case in 2002, this has been repeated in several judgments, and I think a lot of two more minutes. 2 more minutes. Once this situation happened, the learned friend also was mentioning about the NMC. That we have uploaded the name to the NMC website. Correct, but NMC for the last page, second, in the last paragraph, we have time till the 9th. So that is only a formality. So now,
1 year, full 1 year.
Now what happens? Now what happens is, one seat which was admission was made defaults. In this particular, in the subsequent academic year, that seat has to be now given up to the government. No. This process is over. Although the courts have said that this is without all these orders, interim orders are without merit, without prejudice to the rights of party. We will not be pressing on that. Once the student has come in, we are also aware of the fact that we don't need to get the student out of the seat. But we do need to get that seat. So one seat will be given up in the next academic year for the purpose of meritorious student. So give that seat for your improper action to the government quota from the management quota. Management quota is a pricey quota. Base that, give that seat away to the government for the purpose of meritorious care. Because inter se merit in that quota of theirs was given a quota. Ultimately, it's a merit candidate. Now you give up one seat for the purpose of for your improper action to the government, and that one meritorious student. That is your redemption. And the fact that 23 is also there shows that is the reason why we were pursuing that matter, why we were saying that we should do that. They repeated the same thing, same reason, mistake. So the modus operandi is mistake in this case. Modus operandi of doing the college. And that is it. And there are some more communications. It was not that this was the only place where they could say it was a typographical error. to the university. There are emails on the 12th. 13 she left on the 12th. Please point out. Whatever.
The last, immediately when the last date of completion, 12/20. The extension of time for 14/1 was for the vacancies. Extension of time. According to the vacancies arises when not again notified on the PA portal, not by the college. The moment on 11:58 of 2nd of December, in the center email as well, and all 6 admissions, total 6 seats for Miss OPT. So on the 8th of December was the last day to submit the hard copies of the list of documents to the university. That is submitted by the very same. After that, Millers, when the NMC issued the extension of date of 10th of January, that was with respect to the vacancies where there were multiple colleges. In various colleges, there were seats. This seat was never notified as vacant at any point. Even if this girl, the petitioner had she cannot cancel through the college or through the DME. There's a procedure which has to be followed. There's an application form which has to be filled, and they forfeit if you become penalized. And she will not be qualified for subsequent admission. There are consequences for it. That is not being followed. Number 1, number 2. On 5th of January, the 8th of 9th of December, when they submit, still the name of the petition of Dr. Chetra's name is
I have about 10 minutes, my lord.
22nd.
July. 23.1. Abhishek Mali Patil.
There is something more in it. Namely, that the acquisition of violates the merit rule, which is
that was made before your lordships. Lord, I was looking at the statement of objections filed. Without fear of contradiction, I can say there's not even a word merit used in this subject. This is to say that petition number 2 has been admitted over Chaitra, ignoring the merit rule, is not even a case pleaded in the statement of objections. I don't know how this argument is founded. Please look at the statement of objections, my lord, of the medical commission.
There is nothing about.
Not even the word merit.
No, details also.
My lord.
Whether what is the merit of this Chitra, what is the merit of.
Nothing. On the contrary, my lord, I'll give your lordships what has happened. My lord, Chaitra has a merit ranking of 1,17,215. Petitioner number 2 has a merit ranking of 1,05,677. So I ask myself, who is more meritorious, my lord?
So this is part of record?
Is it?
The ranks are found in the record.
Where? My instructions are, it is there, my lord. I'll give you lordships where it is.
All right.
That is point number 1, my lord. The second point, my lord, is there is not a whisper in the statement of objections with regard to how the National Medical Commission themselves have recognized petition number 2 as a student who has been admitted to the college. I showed to your lordships, my lord, the list published by the Medical Commission. In the statement of objections, nothing. In the course of in the submission that was made, nothing.
So number 2 is recognized.
Yes, my lord. Yes. I'll give your lordship that. Petition number 2 has been recognized. I'll give your lordship that, my lord. My lord, your lordship may kindly look at page 50, my lord, for a minute, of the writ petition. Please see page 50, my lord.
Page 15.
50, my lord, of the writ petition. And this, my lord, is as on 2/12/2022. And your lordship may kindly see on the top, my lord, NMC. And the statement of objections, my lord, is silent about this.
So the name of that
Yes, my lord, serial number 6, petition number 2 is found.
Chitra is not figuring.
No.
How?
No, it is not, there is a mistake. They recognized it even as of 2/12/2022. They recognized it. Today, all this is being told to your lordship that, oh, this is all not, this is manipulation. The merit has been given a go by. This is a genuine mistake. They also recognized it. Therefore, even as of 2/12/2022, when they put up this list, they put the name of petition number 2.
If there was a genuine mistake, then how come that the fees were paid at 12?
No, I'll come to that. I will come to that. No, there is a carry forward mistake. I must tell your lordships how I showed your lordships on the face of that receipt. There is a mistake. There is no difficulty about it. I'll come to that, my lord, one by one. First, my lord, I wanted to point out to your lordship that all this argument on merit is, my lord, an argument, my lord, which is not founded upon pleadings. That's the first point I wanted to place your lordships. Second, my lord, the NMC is now stopped from contending that as on 2/12/2022, petitioner was not a student admitted to the PG course. In view of their own,
In your page 50.
my lord, page 50. Now, my lord, not only that, there is another document that I want to show to your lordships. They also published, my lord, a list of all the documents which your lordship will find at annexure X of the affidavit that has been filed by us separately.
On 4th of January 2024.
My lord, it has been filed on the 4th of January 2024. And your lordship gets that, my lord.
Stand by the court officer now.
My lord, the
morning session.
4th of January. Yes.
Lord, please be kind enough to see annexure X. Details of students, my lord, got it, my lord.
January affidavit by whom?
I'm sorry. By whom? My lord, this is filed by us. We have filed it, but we have produced as annexure X at page 17 a notification of the National Medical Commission. My lord, got it. Yes. May I just read the 4 lines, my lord, at page 17? To facilitate the aspiring medical students seeking admission in PG medical courses and state medical councils for registration of additional qualification, details of candidates admitted through NEET PG 2022 examination are being uploaded on the NMC website. Now, my lord, what is uploaded goes on up to page number 20. Please see page number 21, my lord. We have placed for your lordship's consideration a relevant typed copy of the details uploaded on the portal of National Medical Commission. Your lordship will kindly see, my lord, Bhavana T, who is petitioner number 2. This is the document of the Medical Commission. Not a whisper about it, my lord, and I ask myself, are they not today stopped from contending that everything was a manipulation? My respectful submission is, my lord, they are. This is a clinching evidence. Now, my lord, what is put against me as against this? What is put against me is that one document which I need to explain to your lordships. Lord, please look at that receipt, my lord. I understand, my lord, that was troubling me too. Please look at that receipt for a minute. It is filed along with the statement of objections of respondent number 2. a number.
Yes, I'll show in the rejoinder, sir. In the rejoinder, on 1/6. Statement of objections only, we find a rejoinder to this.
Only their number.
Yes.
Yes, but anyway. Your Lordship got that, my Lord. My Lord, please be kind enough to take page number 7. My Lord, page number 7 is a follow-up of page number 6. Please be kind enough to see what has happened in this case. My Lord, if your Lordship ask me the question, have you made a mistake? Answer is yes. Is this the way you run your college? My Lord, much is desired. There's no doubt, my Lord, it can't happen. But the fact is, it has happened now. This is not a desirable way of running a college, my Lord. I'm not for a moment saying that this is the way of doing things. No. But now, my Lord, please see what has happened. Kindly see page 7, my Lord, that receipt. Your Lordship will kindly see that payment reference number, my Lord. All thing is a mess. I'm conceding to that position. But is this a deliberate act of trying to circle around the law? That, my Lord, I would say no. Is this a mistake? Yes. Is this carelessness? Yes. My Lord, please be kind enough to see the payment reference number, my Lord.
The doubting aspect is, my brother is rightly pointing out, that the fees were paid at 2352 at page 6.
Yes, bro.
On 2/12/22.
Yes, bro.
And now compare this with your page 46 in the petition.
Yes, bro.
So that letter is of same date.
Yes, bro.
How could it be written?
That letter is subsequent, bro. Subsequent.
Not subsequent, the same date.
Page number, your Lordships are referring me to page number
46.
46, my Lord. Annexure H.
Acknowledged by the director on the same date.
Yes, bro.
Written
Yes.
on the same date.
Yes, bro.
So either this is fabricated or backdated. Or some you are really fumbled like anything.
No, my Lord, this is on 2/12. On that day, we have written to them that there is a mistake. Please change it.
Following candidate get admitted in our college. Acha, I see. You are writing about their bhavna.
Yes, my Lord.
Not about.
No.
Not about
Chaitra.
Chaitra.
And now your Lordship may kindly say, see, my Lord, just to. My Lord, your Lordship may kindly see one.
So what comes to is that you admit and intimate that bhavna is admitted to this director of medical education.
Yes.
On the same day, you accept the fees of the other candidate.
Now, my Lord, the question is, was it accepted? Was that a mistake? Now, I'll point out, your Lordships, on the face of the document, it's wrong. On the face of it, it is wrong. My Lord, it is a culmination, if I may say so, my Lord, whether I should call it comedy of errors or I should call it tragedy of errors, it is an error.
How do we assume that it is bona fide?
I will show to your Lordships. Please be kind enough to take that receipt. I will show to your Lordships what has happened. Please be kind enough to take that receipt, my Lord, at page number 7. On the face of it, there is a mistake. My Lord, please be kind enough to see page 7, my Lord. And I will show this to your Lordships, and I have instructions to make one submission before your Lordships. Your Lordships can appoint a chartered accountant to find out if really this money has been received from our account. Anything will be given to them. No difficulty, my Lord.
Not received.
No, not received. I stand by the statement that has been made in the writ petition. This is a mistake. Therefore, my Lord, if your Lordships want to be satisfied that in fact, money has not been received. I have no objection. That's the instructions I have to tell your lordships. Please appoint a chartered accountant to go into our books to find out if really the 75 lakhs has been received. No difficulty, my lord. I am making bold on instructions to
How
say
come
that.
that receipt is issued?
I will tell you lots of what has happened. My lord, this is what we have explained in our rejoinder. We have explained that. Now, please be kind enough to see one reference number, and on the face of it, I will show to your lordship that this is all a whole thing, as I said, my lord, is a tragedy of errors.
But then how many explanations?
The whole seat is seat block.
My lord, this is an allegation.
To block it, by issuing, why then the receipt is issued? That is the receipt by which they will then say, we have taken this admission at that time and blocked the seat.
But Mr. Counsel, in all cases, we go on presuming that they are blocking the seat and malpracticing.
What it is, 17 cases of 17 colleges. Recently, there has been an order, one of which has been placed by the Lord before this court. On the last day, this is the game that is played by each and every college. It is only thou shalt not be found out. 11th commandment. When you are found out, and that is why para 12 of our notification which says you have got time for 7 days after the last date to upload the thing. It says onus of furnishing true, correct, and authentic information on the college. It is only when it is found out. In fact, MCI now for the last 3 years has permitted admission to medical colleges without inspection on affidavit. If your affidavit is wrong, and if we come for an inspection, then you will go for 2 years without inspection. So this is transparency that has been set in now. We take your word for it. When we find out that you are not right, and this is another. So if they say we are wrong here, we are wrong there, we are wrong there, we are wrong everywhere. We are wrong in para 8, we are wrong in para 10, we are wrong all over the place. And in that case, suffer some.
That is what we are asking, how long you go on.
Therefore, what I say is a little knock on the knuckles from this court to that college for their action.
Little.
That's all we are.
Little no.
My lord, I think, my lord, that the NMC also should have a greater sense of responsibility as a statutory body before this court. I ask myself, my lord, as a statutory body, are they responsible in making a submission before your lordship without a pleading? Absolutely not a word I can say without fear of contradiction from my learned friend. Not a word to say that merit has been sacrificed. And how do they explain their two documents? It is a mistake. Madam, please be kind enough to see this document at page number 7.
No, not necessary to. Anything further you want?
Nothing, my lord. I want to show on the face of it, it is wrong.
To which page?
My lord, please see payment reference number.
Okay, same page.
Page 7, my lord. Whole thing, my lord, has been page 7 of the statement of objections filed by NMC, my lord. By KEA. That receipt, my lord, that your lordships are seeing.
Receipt, yes.
My lord, kindly see that payment reference number, my lord.
Payment?
Reference number. There, my lord, payment reference number 2336234704449. At page 7, my lord, at the bottom.
Page 7. Yes.
Yes. Now, my lord, what is this reference number? Please be kind enough to take our rejoinder, my lord.
To R3. Rejoinder to a statement of objection to R3.
My lord, it is filed on
1st of June.
1st of June. And if your lordships are kind enough, this is the statement from the bank. Please be kind enough to turn, my lord, to page number 17 of this rejoinder that we have filed to the statement of objections of R3. Sir, sir.
R4.
My lord, to the statement of objections of R3.
Yes.
My lord, would your lordship be kind enough to turn to page number 17? This is a bank statement. I'm now trying to show to your lordship that it is a bona fide mistake that has been made. And bona fides, my lord, can also be careless. There is no mala fide intent in this, as is sought to be made out by your lordships on the basis of this one document.
For June or first?
First June.
1st of June. 1st of June. 1st of June. My lord, I'm given to understand, my lord, that two rejoinders have been filed on the same day, one to R3, another to R4. Your lordship got that, my lord, at page number 17? Lord, please see the last entry on the page, my lord, 2/12/2022, UPI number so-and-so, 70449. It is pertaining to some Sai Priya. I don't know how that number, that reference number comes in this receipt. It has nothing to do with Chaitra.
2336633.
No, yes, 70449, same number. It is some Sai Priya. how, if you ask me, lordship ask me, how did it come? I can only say, my lord, absolute carelessness. But there is no mala fide intent in this. To suggest.
So what does it suggest?
My lord, it suggests only that that receipt is full of errors. Payment reference number is of somebody else. How does it relate to Chaitra? That is why, my lord, please do not base your lordship's judgment on that one singular document. That's a respectful submission I make. Can mala fides flow out of that document is the question I ask myself. Somebody else. And this is the bank statement. Therefore, the bank statement, my lord, must have greater credibility than that document, which we are saying is a mistake, it is a wrong. And therefore, what has been stated in para number 8 of the writ petition is correct. No payment has been received.
Amount is also 77,500.
Same amount.
Not same.
Which one, my lord?
90,000 rupees.
No, the amount is also wrong. Amount is also wrong. Correct? I'm here on the number 70499. Your lordships are right, my lord, I bow down. But if there is any iota of doubt as to whether this amount of 75 lakhs 15,000 has been received,
This. The number of payment receipt is at page 18 last.
my lord. Page 17. Page 17.
18.
Oh, 18. Number change, yeah. That is the entry, my lord, bank statement. Your lordships are looking at the bank statement, my lord.
Anyway,
Mala fides on the basis of this to be drawn with respect to that one document.
we don't know what kind of.
But that's why, my lord, ultimately, my lord, your lordships have to find out as to whether the 75 lakhs 15,000 was received on that day. Please appoint a court commissioner, a chartered accountant to go and look into our books and make a report to your lordships. Then, my lord, the whole controversy will be set at rest. That's all. I have instructions to say that to your lordships.
Letter on the 13th, where she discontinues the course. What is the explanation for that? This whole thing was a seat blocking exercise. That's what I'm telling this court. That the seat blocking is done at the last moment. At that point of time, so that later Chetra can be deleted and put there.
My lord, all this,
If my learned, now I'll also take up the country. If my learned friend wants an investigation, it will be a very simple investigation. Let there be the family member's account. Now, my lord, we are, my lord, not far from business as a background. So now I will tell this court, this, if they are very firm on this, I do not mind that, because I have nothing to say against anything. I will then put it like this. Let Chetra's total family accounts, because from where payments are made, it's not necessary that I will be paying from my account, father's account to be full bank accounts and payment details from start to finish of Bhavya should be brought forward, and also for Chetra. And then Chetra also, since she has been admitted, should also be brought before this court. And if it is found out, then in that case, that would be a complete investigation. Nothing wrong in that. I am not shying away from that. And I'm not saying to this court also, don't go into it. But then, once that happens, then the fraud will become more explicit. Or they will be truly able to establish that they are not there. But not with this. This per se shows first block the seat at 2352. If they want to stop it at that with a knuckle or a rap on the knuckle, I say that is fine. But if it is to go deeper, then the real truth will come out with the entries. Because I'll tell my lord this. College is key, DD is ready. Those DDs are used for the purpose of admission at that point of time. Because nobody goes into it. These things happen only when, the Lord knows, big crimes or small crimes. It comes out only when there is a loose end. And a loose end happens because of the commission of a illegality. Let me put it that way. Let me not use a bigger word. There will be something which shows.
Career is more important than crime.
That's all. The only thing is, and it has been mentioned clearly in my affidavit, that it is inter se merit which has been given the go by. As far as my.
So heard learned senior advocate Mr. Raghavan for the assisted by learned advocate so the appellant, learned advocate Mr. For respond number so and so, learned advocate Mr. So and so for at length. Learned counsel for the respective party stated that they argued the petition appeal finally. They further stated that the pleadings are over and no further are required to be added or supplemented. Reserved for judgment.
new money.
What about 23?
23.
Not today now. Day after tomorrow.
Day after. Wait just.
You are appearing in that.
Yes, but I have the college.
Tomorrow though will not be possible. Day after to come back. That matter. Insolvency code matter. Tentatively day after tomorrow. One matter is kept. We are not sure when it is kept. If that will have to be given precedence because it's already started. So for the time being, day after.
Okay, we'll be here. We'll keep.
You for it.
Grateful.
ABC code.
The 230 matters, seal number 77. Venugopal MS.
Number 75. Why it is kept? Yeah, after two.
Seal number 78. Shri
I-
Srinivas K.
I appear for the petition.
78.
My Lord, I appear for the complainants in these cases. The direction issued by the learned single judge, my Lord, in restriction number, my Lord, is at annexure C. Lord, the operative portion, my Lord, is at page number 41.
So what happened?
That is produced only two of the, my Lord, replies given by the.
That is considered, yes.
Your Lordship may
Page-
kindly see the
Page.
page number 45, annexure E is one of the reply given to, my Lord, the complainant number 1. Kindly see, my Lord, page number 46, what is the reply given by the accused?
No, you're representing the same subject matter is considered.
I have represented seeking for 3 benefits, my Lord. One is EL encashment. The another is, my Lord, the 1992 settlement arrears. The third one, my Lord, is the interest on gratuity as per the orders passed by the controlling authority. So they have, my Lord, adverted to only one item, and the other items they have replied that once the financial condition improves, we will pay the amount. That is not the, my Lord, what is, my Lord, the directive. They cannot, my Lord, keep me under, my Lord, tantrums for another.
Activity, interest and pay revision.
Yes.
They have said what they have said.
EL encashment, my Lord, that has not been paid. Till date, my Lord, I have retired in 2011. It's almost, my Lord, 13 years. And some of the complainants, my Lord, have retired in 2001 and 3.
First comprehensive order in relation to all 3 points. We are suggesting a simple solution. To decide the representation by passing a comprehensive order dealing with all 3 aspects.
Let them pass. Has not been passed.
He says that it is considered only in respect of one aspect.
Yes. No, I produced the very reply itself, my Lord, at annexure D, annexure E, page 45. Their own reply, my Lord, which has been given to me after my representation in terms of the order passed by the Sambo court. Page number 46 is the reply, wherein they says that once the financial condition improves, they will pay the earned leave encashment amount. Just virtually, my Lord, in fact, my Lord, the government has released 110 crores, my Lord, in 2018 only for the purpose of payment of retirement benefits to the employees. More than 20 years have lapsed, my Lord. They cannot keep me under, my Lord, the tantrums for any longer time.
This is pay revision. Pay revision. 1992 pay revision.
That is one aspect, my Lord. EL encashment is also there.
You're aware about that petition decided by us.
That matter, Lord, 1997.
97 revision.
We are not asking for 1997 arrears, my lord. I am confined only to 1992 arrears along with interest and the encashment of earned leave. The third, my lord, is the compound interest on gratuity amount as per the orders passed by the controlling authority. So these are the three items.
What is your stand, Mr.? So you find out judgment that financial crisis is a good defense in contempt. There is a one judgment. Financial incapacity is a good defense in contempt. You will find somewhere, at least in some high court judgment. Some probably Gujarat High Court. To find out that, then we'll take up. Otherwise, you have to comply with you.
Order, read one paragraph, every single order. Para 3, given search by the petitioner in this section, is regard to the field of arrears.
23rd of July. Yeah. Next.
Final reading matter, seal number 79.
I appear for the petition.
Yes.
Yeah, this is a revision.
Because there's one altered matter treated outside council. as
This was,
Can I request for that?
yes, this was earlier heard.
Yes.
Heard. 26 or 7.
Lord,
28.
short date because Lord, right from 2017, the quarrying is going on in the forest, in the reserved forest.
It's not reserved for this.
Day after tomorrow. Tomorrow
Please.
there is a bench there.
Please. At 2:30, Lord?
Not at whenever it reaches.
Because, Lord, your lordship.
No, if earlier reaches earlier, otherwise 2:30. If reaches earlier, then earlier, otherwise 2:30.
Please.
It parted in the morning.
Only 2:30.
I'm sorry, my apologies for that. I own apology.
No problem. No problem at all. 2:30.
Seal number 26. A. Murali, 26.
And my lord, the allegation is I have disobeyed the order of the learned judge, where I was directed, my lord, not to put up any additional. My lord, my respectful submission, my lord, I have not put up additional nor any concern. What I did, my lord, there was a painting done there because the rains were coming. I was made to stop the construction from the month of March itself. When they filed the petition, they got an interim order. And this surprisingly, my lord, is when the learned judge was given me, one single judge was given me an opportunity to adjudicate this matter for the sanction authority, for the commissioner. Because, my lord, the allegation is I have made setback violations in my property. This is not possible because, my lord, the same authority has given me a commencement certificate after inspecting my property, in which I had, my lord, put up my basement and columns. Once that is done, the lordship, I cannot expand my foundation to do a setback violation.
Where is the appellate authority? You are for appellate authority?
My lord,
You are for whom?
I am for the accused, my lord, 7 to 14. 7 to 14.
So what is the breach?
My lords, I'd seek your lord's indulgence in comparing few photographs. When I'd file a writ petition before a coordinate bench of this honorable court, in page numbers 214 to 16, I've produced the photographs. The status of construction of the property in February 2024, page number 214 to 216. Then that writ petition was finally disposed in terms of Annexure D. by way of order dated 3rd April 2024, wherein they were given the liberty to approach the appellate authority with the condition that they shouldn't put up any further construction before obtaining a stay. My lords, in this meanwhile, in this time, like from the date of order and the date of filing of this contempt petition, they have carried out certain additional constructions, and the same can be seen photographs, which has been produced as produced as annexure E to E4 in the petition in page number 230. Comparison of photographs in page number 214 to 216 and page number 230 to 234 will establish why I filed this contempt petition.
What are the directions?
My lord, it is at page.
Not to put up further.
Yes, my lord. Page 228, my lord. The petition is disposed of. May I read it, my lord? Of directing the private respondents not to put up any further construction in the subject property unless they avail the statutory remedy against the provisional confirmation order under section 253 of the BBMP Act.
You moved an application for appellate.
That is pending adjudication, and the matter is coming up for hearing on 29th, my lord. Another hearing date was fixed, and my lord, that the hearing did not happen. This is my first hearing there, and it happens once in a month, my lord. My construction is stopped. My lord, I brought to the notice of the learned single judge, my lord, this, I have not done any kind of a deviation. And it is actually, my lord, the complainant herein, he is my neighbor, my lord. He is the one who has committed 100% setback violations, my lord.
But this will be decided, this.
Your lordship?
Leave to continue with the construction.
No, I have not made any construction, my lord.
No,
I filed an affidavit.
You said you filed an application before the appellate authority.
I have made an application to adjudicate, my lord, because there is an order passed against me, which was not, I was not served with the notice at all, my lord.
Let us wait till that.
My lords, I'd like to bring to your notice. The writ petition was disposed on 3rd April 2024. I filed this contempt petition on 8th May 2024. They have gone and approached the appellate authority only on 5th June 2024.
My lord, I got the order copy, and after the order copy is got, it was actually, my lord, the standing committee was there earlier to adjudicate this. The standing committee is now, because the standing committee is not there, it was a commissioner. So I had my personal difficulties finding that and filing that with obvious objections and things.
So this leave to carry on construction was filed?
Leave to carry out construction was filed. I have filed it before the commissioner, my lord, BBMP. I have filed an application.
Appellate authority.
My lord?
Leave to continue application was filed before appellate authority.
The appellate authority, the commissioner, the appellate authority and the commissioner.
What happened?
My lord?
What is happening there?
The hearing, the first hearing is coming up on 29th of this.
So we wait for that.
My lord, if on 3rd April an order
my
was
lord, I
passed,
filed an affidavit that I have not made any additional.
My lord, they were given
Entire construction is stopped. My lord, it was all that is required was for 1 month construction. I have moved into a rented apartment, my lord. I was living there from 1963. My father built a house which became dilapidated. I am rebuilding it, and my neighbor who is sitting there with the double side, committing 100% deviations there.
You are not making any construction.
I'm not making, my lord. I filed my affidavit there.
Right now also not.
No, my lord, I stopped it completely. I unloaded one load of marble there, my lord, which I had ordered, which had come there. I kept it there. And this additional construction is completely false, my lord.
My lord, at least until
file undertaking before this court.
My lord, I filed already. The affidavit has been filed. Today morning I filed.
It's a counter reply. If they file an undertaking that no construction will be carried out.
I have filed an undertaking before the court itself. I told I have made an undertaking on the first day when I appeared before the court. I'll stop my construction.
Very good.
No, in the learned before the judge, my lord. And this today I have filed, my lord. Today morning I filed the counter, my lord, when I told I have not made any constructions.
It is
But
not.
during the pendency of writ petition, they didn't carry out any construction. But between the time the order was pronounced in open court and between the time I filed my contempt petition, they have carried out.
My office copy may I apply first? I filed it today in the morning. Today morning.
And my lords, page number 144 of my contempt petition, they're marketing this property as residential apartment, you know.
So this might be enough, my lord. So this is enough. They have said there's no construction.
My lord, if orders can or direction can be issued, they will not.
You show that there is a subsequent construction.
My lords, I have produced photos, my lord, along with the contempt petition. Annexure.
There are earlier photographs.
My lord?
Compare with the original photographs. Compare with the original status. How do we know that is latest?
My lords, photos, if photos in page number 214 to 16 are
How do we
compared.
know that it is an improvement in the construction?
My lords, because they completed the plastering work, they completed the
We do not
RCC
know
work.
that on that day plastering work was plastering work was not there. So to show that photographs of that point of time and compare the present photographs.
My lords,
Lordship may say there are not a single person there, my lord. I don't have any color photo what they produced.
Second will take up.
Your lordship.
We have carried out construction.
No, my lord, I have not carried.
Take up on.
my lords, if direction can be passed that they shouldn't carry out any.
Let them do it. We'll take up on Tuesday, next Tuesday.
Much.
27 agenda number 28, Mr. Bharat Kumar S.
State, my lord.
My lords, kindly pass over the matter. Pass over. My senior is engaged. May I pass on a brief synopsis, my lord, of the case?
On that day when taken up. 26th of July. at the request of learned advocate for
Respondent number 5.
this.
Please. Any convenient date to the court?
Any convenient day. You want next year,
26.
next year.
No, my 26/7.
It appears that you want next year.
My lord?
It appears that you want the matter to be taken up next year.
No, my lord.
So when do you want to take it?
26/7.
Why 26/7?
Any convenient date?
Today itself it is convenient. Proceed. You must argue the case. Why you are so casual?
Senior is engaged in this matter. Senior is
You
engaged.
don't know which date to be asked for from the court. That much also you don't know, Mr. Counsel. You are before the High Court and the First Court. Don't be so casual. You don't know which day to be asked, in what way to be asked. What we say, you accept it. We say next year, yes, next year. We say next century, next century. Be ready and come before the court. At least know what is the subject matter. Do you know it? You don't know the date asking. How do you know the subject matter? Next.
Twenty-nine urgent, seal number 30.
Yeah, for the
Shall you
petitioner, my lord. Yeah, for the lords. Then I request a passover, my lord. I request a short.
So not possible.
Lords, any date in this week or next week, subject to the convenience of my lords.
This is already heard.
My lords, this is heard. This relates to the forfeiture of 16 crore rupees as bid
Is that,
security. Yes, my lord.
Seal number 31. Mr. Ravi Shankar K.
My lord, kindly, this matter is taken up along with serial number 57, my lord. It's a similar identical matter, my lord. Engage the services of the senior advocate. Ready with the matter, kindly. 57, 57.1, 57.2, my lord. Identical matter has been posted, my lord. On the last date of hearing also, my lord, this honorable court tag on with the present petition along with WP 6869 of 2024, my lord. But by oversight, office has shown as year 2023 in the cast list.
This is census.
Please,
So all matters are to be heard together. It will require a fairly long argument to consider controversy. So when other matters are coming.
It's at serial number 57 today.
Now you can withdraw it. Withdrawing?
No.
Not yet. Now there is no hurry. Any hurry, any, no. No hurry.
Kindly call along with serial number 57. Ready with the argument.
Tell about this, now there is any hurry?
No, my lord, in identical matter, my lord.
Earlier it was earlier in the month of April. But how come you are not seen in the earlier round of hearing? You are not seen with this matter in earlier round of hearing.
Sorry, my lord.
You are not seen with this matter in the earlier round of hearing.
The last date of hearing, my lord.
You were there last.
Please.
It will go to some, when other matters are kept.
Not the serial
Find
number.
out. Today.
Today.
To argue.
Lord, I'll
Yeah.
In this matter, my lord, engage the services of the senior advocate. Kindly take 57. When
This is
it
what
was
we
reached.
say, there is no hurry. You want
Total number.
some senior to come.
Please.
Who is, you are also looks like senior.
No, engage this designated senior advocate, my lord.
You are not senior. You look like senior and all are seniors. Why you make a distinction between junior and senior? We never make.
Please, on the last two occasions, my lord, the designated senior will address the argument.
So some other day. Some other day.
Please.
Number 32, to Govind Raj K. Number 32.
I am for the petitioner in this case, madam.
PIL can't be argued from video conference. You must be here.
That, my lord, in this case, my lord, license was obtained to remove the ordinary sand from the river, my lord. That river runs in a U shape, my lord. That naturally formed this sand buildup, my lord. In that, they are extracting the sand, my lord. There is a upstream to about 250 meters vented dam is there, my lord, and 2 kilometers in downstream also vented dam is there, my lord. That naturally formed property, that's a government land. From there they are extracting the sand, my lord, and by obtaining a license from the river, my lord.
Appearing for respond number 8, Your Honor. Appearing for respond number 8, the executive engineer, Your Honor. Your Honor, the respondent authority, that is respond number 4, has given the permission to extract the sand, Your Honor. And the survey number which is in question is 181, which is a government land, Your Honor. And the government has permitted extraction of the sand, Your Honor, which is situated at Karkada village, Brahmavara Taluk, Udupi, Your Honor. Your Honor, as it has been mentioned by the Learned Council, Your Honor, they are saying that it has been situated, the present query is situated right near the upstream side, that is 260 meters, and the same has been licensed to the respondent number 4, Your Honor, on 21/12/2023. Your Honor, the query place that is at 260 meters on the upstream side, Your Honor, and the vented dam at 2.8 kilometers on the downstream. Your Honor, before passing of the license, it is very much important to pass a environmental clearance letter, Your Honor, which was given on 28/11/2023, Your Honor. Your Honor, kindly look into Annexure E, page number 64, Your Honor, the clearance certificate. Your Honor, in the clearance certificate, page number 71, condition 44. Your Honor, it has clearly stated that mining shall not be undertaken in a mining lease located in 20 to 50 meters of a bridge, 200 meters upstream and downstream of water supply irrigation scheme, 100 meters from the edge of the national highway and 50 meters from the reservoir, Your Honor. In the present case, Your Honor, it is 280, it is 260 meters from the upstream, which is beyond the 200 meters, which has been mentioned in the condition as given in the clearance certificate. And also, Your Honor, 2.8 kilometers on the downstream, which is beyond the limits which has been mentioned. Hence, it is not hence it is not against, and the license which has been given is legitimate, Your Honor, and the extraction has been done as per the license granted. Your Honor, and the very important point that I would like to bring to the notice of this court is the petitioner, he himself is an illegal extractor, Your Honor. He is an illegal mine extractor, and against him, several occasions, there has been penalty being issued, Your Honor. Your Honor, to prove the same, I would be giving the documents, Your Honor. I'll be producing the documents before this honorable court. Violation on fine that has been paid by the owner, that is petitioner number 2, Your Honor. He is the owner of a vehicle registered number KA20A7777, Your Honor. And it has been clearly been confirmed by him in the same document which has been produced before this honorable court right now, page number 4, Your Honor. He has given a Helike Patra, Your Honor, that is a declaration letter, and the translation copy of the same is also given in page number 30, Your Honor. Your Honor, he is stating that I hereby declare that the vehicle number KA20A7333 belongs to me and I am the owner. He is against him, Your Honor, they have been giving notice against him for illegally transporting, unauthorized transportation of minerals, Your Honor, since 30/9/2022, Your Honor. On 4 occasions, he has been doing the same thing, and it has come to the notice of the authorities who are handling the mines and geology, Your Honor. On 30/9/2022, which is the page number 3, Your Honor, we have already produced, and on 28/11/2022, Your Honor, and also on 14/12/2022 and 8/5/2023, Your Honor. On several occasions, he himself is illegally exporting the sand, Your Honor, and he has filed this petition in the public interest. When he himself is not come before this honorable court in clean hands, how can he file a public interest litigation, Your Honor? He himself is an extractor, Your Honor, and in the present case, the license has been issued by the government to extract the sand from the particular area, which is within the limits, Your Honor, as per the as I have already shown before this court about the clearance certificate. It clearly says that 200 meters from the upstreams, and also same for 50 meters from the downstream, and also from the reservoir, it should be 50 meters, Your Honor. In this case, it is 260 meters from the upstreams, 2.8 kilometers from the downstreams, and also 100 meters, more than 100 meters from the dam area which has been located, Your Honor. Your Honor, in this case, the petitioner is only misusing the process of this litigation, Your Honor. He is trying to collude with the petitioners, and he has filed this petition only with the motive to cancel the grant of the license which has been given to the respondent number 8, Your Honor, and they are trying to illegally extract the sand, and also with the ulterior motive of gaining something in return to get an undue advantage of this place. They have filed this PIL, Your Honor. It is nothing but abuse of process of law, Your Honor, and I request this petition to be dismissed with cost.
Kindly see. Yeah. At the outset, I submit, this is not a public interest litigation. All the representation given by the petitioner himself, but for H1, all the other representations are addressed by the petitioner himself, and that has been answered also as per Annexure J. Annexure J is the document dated 18/1/2024. This representation has been answered, stating that the lease granted in favor of the private respondent herein is in accordance with law. And he is seeking to cancel the lease deed executed in favor of the private respondent without pointing out any violation on their part. And his representation has been answered. There is no substance in this petition. Therefore, I request this honorable court to dismiss the petition with exemplar.
Yes.
Your Lordship, appearing for the respondent number 7 board in this matter, Your Lordship. There is no grievance as such except considering for the representation in this matter, Your Lordship. And I would be sailing with the arguments of Mahindra sir and the other respondents, Your Lordship, in this matter.
Who is for the petitioner? Who is for the petitioner?
Govindraj?
Mr. Govindraj, you are for the petitioner.
I am for the petitioner in this case, my lord.
What do you have to say?
Page number 114 is that, my lord, the photographs I have produced. That U shape is there, my lord, river flowing in the U shape, my lord. That 114, my lord, L1.
So any further thing to be submitted?
Sorry, yes.
Anything to be submitted more?
Yes, please.
What is, then come tomorrow. Tomorrow at 11. Come physically, tomorrow at 11.
Please, ma'am, please.
It's a pleasure.
Day after tomorrow, my lord.
Day after tomorrow.
Please.
At 11.
Much obliged, Your Honor.
Insofar as they are considering the discourse.
See,
36, my lord.
26, serial number 66, my lord.
who is opposing you?
Muthoot Finance.
First.
That there is a 24 lakhs has been deposited before this honorable court since 1.5 years, my lord.
On first we'll take.
My money, my lord, therefore please, my.
That's
and
right,
I'm
but
in
we are,
financial crisis and my daughter is physically disabled, my lord. That's why, my lord.
on first we'll find time for you. First. You.
Serial
you
number,
for reading.
serial number 36, my lord.
This Kavartin person is pressing.
My lord, it is since
Let
1.5
us-
years. alas,
let
only.
us see what is the
Since
matter.
4 years they are dodging the matter, my lord.
Yes. We are not arguing the matter. I arguing. Come on first or second, whenever you want. First.
Serial number 36. Serial number 36.
Serial number 76, my lord.
Serial number 36, my lord. My lord is, the respondent is out of the job, my lord. They have suspended during the pendency of the criminal petition. It's a false case. And they have reduced the subsistence allowance to 25%, my lord. They were paying the 75%. Now they have reduced the subsistence allowance also, my lord.
Get the date.
Lord, start date
Serial number
tomorrow.
46, my lord.
45 minutes.
Serial number 56, my lord. I'm sorry, my lord. I think
45, I have directed this by this honorable court.
58 serial number, my lord.
Open notifications, my lord. Next to in age is about 82 years, my lord. Interest on contempt is there. Next week, my lord. I'm requesting some.
We are saying
tomorrow, day
what?
after
We are
tomorrow.
saying yes.
My lord.
We are saying yes.
Yes.
The serial number
My lord,
56,
serial
my lord,
number
my lord has
51,
heard
my
this
lord.
matter. It is fish cutting matter, my lord, will be taken next week. My lord. Then see.
That's serial number 77, my lords. The worker is out of employment for the last 3 years. 17 wages is pending, my lords, matter.
Two more,
Yes, ma'am.
all two, you are also two more,
45 minutes.
Two more.
Date me tomorrow.
two more.
My lord, serial number 51,
Yours also,
my lord.
two more, two
Day
more.
tomorrow.
You want two more?
Mine, tomorrow.
Two more, two more. No, two more, not day after.
36. Tomorrow.
We are giving early date.
Please.
Yes. ma'am.
36, day after
My
tomorrow.
lord, 76, serial number.
What do you want?
The first matter, my lord. First matter,
First,
24 matter.
first July.
Yes, my
All,
lord.
first.